gon' talk about it. Let's talk about it. Get in here, we in here tonight. So get in here, we in here to vibe.
Hey, everybody. Let me know if you can hear my voice. Let me know if you can hear my voice. How's everybody doing? It's in the middle of the day, y'all. Yes. Let me know y'all doing all right. Listen, we was up late last night, y'all. It was kind of late. Your girl was tired, but hey, I am here right now. All right. But let me know if you can hear me. Okay. Yes, yes, yes. I can hear you. All right. So you guys, we are going like last night. Let me just say this. As I was I went live late last night, okay? It was late and I started getting sleepy. So I know some of the things that I left out and I wanted to come back and I wanted to do this again. But what I did, I went through it and I put my own well, not put my own, I shouldn't say my own. I broke down some things even more to my own understanding, okay? So, and hopefully, you know, for you guys understanding as well. She said we had a sleepover. Girl, I was tired. And once I started getting tired, I started talking kind of crazy. So I was like, what all did I say? Right. So, but I wasn't sleepy the whole time. Like maybe the last hour, I started getting sleepy. So anyway, because I had been up with the grandkids and things like that for the last few days. So I was tired. But I have a document that I want to break down. Now, I'm only going to show it for a brief second because I don't want you know, to have any type of privacy complaint. Not that someone is doing this, but YouTube have their own AI system that goes out and grabs this stuff. So anyway, I just want you guys to know that I do have all of it, all of it, all of it, all of it. Okay. So anyway, I'm going fast because I don't want YouTube to try to flag me for anything. So we're gonna get into this document and we're gonna break it all the way down. And I have some notes to explain further what things mean. Are you guys ready? Now, before I get into it, the title says, and y'all hit that thumbs up button for me, please, and thank you. The title says, the Holly Johnson case takes a turn after defense introduced new evidence. Now, she said, I love your commentary. I love how you tell the truth instead of flat out lying to appease your audience. Keep keeping it real and more. Thank you so much, Margot. I appreciate that. I absolutely appreciate that. Okay. And yes, I'm going to tell the truth no matter how much it hurts anybody's feelings, honey. I heard today, I woke up today with people texting me saying, ooh, they big mad at you. They big mad. Well, baby, they only going to get madder because the defense has entered the ring. Okay. The defense has entered the ring. Thus far, they have been getting one side of the story, and we kept telling them to hold on, right? But they didn't want to hear that. They just kept on saying, she said, you are the GOAT. Hey, Tammy, girl, I was gonna reach out to you, but I was like, let me just wait. But thank you, baby girl. Listen, I know y'all probably somewhat celebrating, but don't celebrate too hard now because we still got a long road to go. However, we are gaining some grounds, okay? Because the defense has entered the ring, all right? The defense has definitely entered the ring. She said, yes, they are mad. Yes, I got a few texts this morning saying that they were mad and mad at me, got my pictures on their thumbnails and in their videos saying that I exposed the witness. Baby, the witness is in public documents, okay? Stop playing. All four of the witness names are in public document, okay? I know all four of the witness, Carlos being number one, the DoorDash driver, which I know his name is number two. The Botello is number three, the Hispanic girl, and number four is the cross guard. Okay, I know all four of the witnesses. It is public information. Anybody can pull it up and go see it. Okay, stop playing. Ain't no witness protection bullshit around here. If it was witness protection bullshit, they would have redacted the names. Every last one of the names is public information. Fuck what they talking about. Okay. So anyway, and then they release Holly's mama information. So go cry yourself a river and stick your thumb dead up your ass and then in your mouth, because I do not care, okay? The witness names is public. They put Holly mother photo on their Facebook and had it floating around, okay? So anyway, ain't nobody protected, ain't nothing redacted. If it was redacted, we wouldn't know their names, okay? It's not redacted. It's in the paperwork, all right? It's in the motions. Stop playing. And they can't intimidate me. They can kiss my ass for all I care. But I do appreciate the free promo. Keep on mentioning my name. I don't give no dams. Keep mentioning it to the highest mountain, okay? Make sure you spell it correctly. Amoira, okay? But nevertheless, let's get into this tea. All right. So I did highlight some information that once we get into it, I'm going to tell you why it matters. All right. Now, first of all, we have to understand that this motion was completed on December the 22nd, and it was presented on the 23rd of December, and it was to be read on January the 7th, okay? And I say that because I've already heard a content creator try to say, oh, thank you, big sis Glenn. She says, hey, I'm more minds and sis, I'm speaking and I am out. Happy Sunday. Okay, girl, thank you. Be careful at work. So I already heard a creator try to say that that this was already heard before the courts and the judge already denied it. That is not true, you guys. That is not true. This motion is to be read on January the 7th, okay? All right. You just have to file it early, and it was filed early, but it is to be read on January the 7th. So let's get into it, you guys. Let's get into it. This is a motion for relief pursuant to Illinois Supreme Court Rule 604H. All right. So I'm not going to get into all the preliminaries, meaning now come the defendant, blah, blah, blah. We already know the defendant is Kadeja Johnson, but for the purpose of this video, we're going to call her Holly because we've been calling her Holly all along, okay? So we're going to continue to call her Holly where it actually says Kadeja, all right? Now, it says on or about September the 8th of 2025, the defendant was arrested for the offense of first-degree murder amongst other charges, all right? This was on September the 8th. It says on December the 4th, Mrs. Johnson appeared for her initial detention hearing. And following that hearing, Mrs. Johnson has been held in detention. The state of Illinois has abolished the requirement that a defendant post monetary bail in order to grant pretrial release, meaning they have no more cash bonds, okay? In the state of Illinois, no more cash bond, all right? However, on July the 18th, July 18th in 2023, in Roe versus Raul, it says the court held that the Public Act's abolished monetary bail was constitutional, and the courts further ordered that a stay of such pretrial release provision was vacated as of September 18, 2023. So again, basically what they're saying is, yeah, in December of 2022, excuse me, what month? Yeah, they said in December of 2022, they took away they did a no cash bond in Illinois, but in September the 18th of 2023, they vacated that and said, holding them to a pre-trial or whatever all the way until the trial date was basically unconstitutional, okay? It was just not right. So because of that, as of September the 18th, 2023, a defendant may only be denied pretrial release upon filing of a verified petition by the state and after the court holds a hearing and make required written findings, all right? Upon verified petition by the state, the court shall hold a hearing and may deny a defendant pretrial release only if the defendant pretrial release poses a real and present threat to the safety of any person or persons or the community. And based on specific articulable facts of the case, and the defendant is charged with a forcible felony. So basically, the defense attorney is saying, you guys cannot legally and lawfully hold Holly unless she poses a real and present threat to the safety of anybody or the community, any persons or the community. And without the threat to any person or the community, she must be released, okay? So now we all heard in court on December the 4th that the state attorney presented a fist bump that says she should not be released because the fist bump showed no remorse. It showed that she deliberately and intended to kill Romika and celebrated afterwards with her boyfriend. They said that fist bump was celebratory of a kill. The judge had no proof of that. He took the state attorney's word and he agreed and said, you know what? Because a fist bump exists, I will keep her detained because that shows no remorse and it shows that you celebrated a murder, a kill. They actually say it does not show that it was self-defense because you celebrated. Again, the judge was shown no evidence. The judge was shown no evidence of a fist bump. Now, the state attorney, what happened? When they presented the fist bump to the judge, they soon afterwards said, there is CTA video footage. Now, what they didn't say is there CTA footage of the fist bump. They said it's CTA footage of some of the incident, is what it said. Well, we learned last night, and we're going to learn again today, that the CTA footage and no other camera whatsoever captured a fist bump. That fist bump was solely something that witness number 3 inserted in her statement, and it wasn't even in her initial statement. It was sometime afterwards. She came back and inserted that statement. Okay? So let's continue. So again, the only way a defendant can be held and not released during pretrial as if they present a real and present threat to the safety of any person or persons or the community. And if they're not a threat to a person or the community, they must be let, or they must be released. They must be let out. All right. So it says, pursuant to Illinois RSCT rule, following a detention hearing as a prerequisites to appeal, the party taking appeal shall first present to trial court with a written motion requesting the relief sought on appeal. All right. So basically, this is what the defense attorney is doing. She is doing an appeal to the first denial. There was a denial for her release on day 1, December the 4th, the first court hearing. She's doing an appeal, and basically she's saying, because of the new evidence that we now have. See, the state had evidence on December the 4th, but that wasn't a time to present it. January the 7th will be the first time that evidence will be presented. So January the 7th, the defense attorney tend to present this motion along with a lot of evidence, exhibits, okay? All throughout this motion, she lists clips of video footage and photos to back up her story. Also, other case studies that reference what she is trying to get done for Holly. There's other case studies where they had to release because of this, that, and the third. So she's using case studies to support her request for Holly Johnson to be released from detention. All right. So let's continue. It says a court may only deny release if the defendant fulfills one of 6 categories of offenses and meet the corresponding standard of threats to the complaint and has a high likelihood of willful flight to avoid prosecution. Okay? When it is alleged that pretrial release should be denied to a person upon the grounds that the person present a real and present threat to the safety of anybody or the community. All right? It also says, additionally, at all pretrial hearings, the prosecution shall have the burden to prove by clear and convincing evidence that any condition of release is necessary. So basically, she's saying, I'm going to prove to you guys that Holly does not, by law, deserve to be still detained. And she says, and the prosecution have the burden to prove by clear and convincing evidence that she should still be detained. So she's not saying only listen to my side, Your Honor. She's saying, I want you to hear my side, but I want the prosecution side, the state attorney, to be able to give a reason why she should not be released, because that fist bump is not going to hold up on January the 7th. Okay? All right, let's continue. All right, so the argument, it states, there has been a change in circumstances sufficient to a warrant redetermination in Holly Johnson's detention status. In recent cases, the appellate court has held that a circuit court must find change circumstances before it alters an existing order to detain a defendant. So she lists different case studies: People versus Cervantes, People versus Walton, People versus Thomas. So that's 1, 2, 3 cited court cases that she cites, saying that these court cases, basically, let me see, it says the court in Walton reasoned that a decision to detain, however, requires no ongoing management by the court, and there will likely be no reason to revisit it unless circumstances have changed or new information has come to light. So basically, these court citings basically saying these people were let go because of this, that, and the third. So shall my client be let go because of new evidence that was presented. Now let's explain the new evidence. When the defense attorney first went to court, the first appearance, she did not have any discovery from the state attorney. So she had no idea what the state attorney was working with. No evidence, no video footage, no body camera footage, no CTA footage. She had nothing to work with. The only thing that she had was a restraining order in which her client, Holly Johnson, presented to her. That she had a restraining order and also a right to carry, okay? A FOID card, I think that's what you call it. But other than that, she did not know what the state was working with. She did not know what the evidence the state was going to use to defend their case. She didn't know any of that. So from that time and to the time that she submitted this motion, she was presented with some evidence. Now, I don't know if she received all of it or not, but as of right now, the defense attorney is stating the evidence that she has received does not support Holly Johnson being detained until trial. And furthermore, it does not support anything that the state star witness has reported, has testified. Okay, so let's continue. All right, it says this new information constitutes a change in circumstances. I think I read that one. Let's continue. It says the state is unable to meet its burden of proving by clear and convincing evidence that the proof is evident and presumption is great. Holly Johnson, in fact, committed this offense. So she's saying the state is unable to meet that burden to proving by clear and convincing evidence that the proof is evidence and presumption is great that Holly Johnson, in fact, committed this offense. Now, let's talk about the offense that they're talking about. It's not talking about the offense that she unalived Romika. That's not up for debate. What's up for debate is she unalived Romika with the intents to KI her, okay, for the sole purpose of, and with no justification. Let me put that. To unalive her, to the intent to unalive her with no justification. That is what the state's saying. The state is saying Kadasia Johnson unalive Romika with the intent and no justification. She did it intentionally, maliciously, with no justification, meaning that she meant to do this and she is not justified whatsoever. That is what the state is saying. And the defense attorney said, whoa, hold on, wait a minute. Wait a minute. You are unable to meet the burden of proof by clear and convincing evidence. Okay? You are unable to do that. All right. It further goes and say the circumstances and facts of this case do not weigh in the favor of any of the factors courts consider when determining whether a defendant poses a real and present threat to the safety of any persons. The state bears this burden of proving by clear and convincing evidence that the proof is evidence of presumption great that the defendant has committed an offense listed in 725 ILCS and all those codes, right? It goes on to say, regarding the charge, the state has the burden of proving that Mrs. Johnson had the intent to KI the deceased Ramika without a lawful justification. The state cannot prove this by clear and convincing evidence. The state cannot prove that Mrs. Johnson intended to KI or do great bodily harm to the victim without lawful justification. When Holly acted in defense of herself and her 6-month-old son. Now, in establishing self-defense, the defendant must show some evidence that unlawful force was threatened against them. The danger of harm was imminent. The defense was not the aggressor, and she actually believed that a danger exists, that force was necessary to avert the danger, and the type and amount of force was necessary, and that her belief was reasonable. So then the defense goes on and she cites another case. This is People versus Hawkins, okay, in 1998. It says, additionally, whereas the law does not require the aggressor to be to be armed for self-defense to be justified, it must appear that the aggressor is capable of inflicting serious bodily harm without the use of a deadly weapon and is intended to do so. So she basically cites this case, People versus Hawkins, in the 1st District in 1998, where it goes into law and says she don't have to have a weapon for self-defense to be justified. The law does not require the aggressor, Ramika, to be armed. This is law. Okay? Then it goes on and say, all such aforementioned factors have been met in this case, and such is follows. What the state has failed to capture and sensationalized throughout the reporting of this case is the reality and the truth. The victim had consistently and thorough various means threatened the use of unlawful force against my client, Mrs. Johnson. Mrs. Johnson, closest friends and family members have all been subjected to the victim's instant and concerning harassment. So basically, she's saying the state failed to capture and sensationalize, I'm probably fucking that word up, throughout their reporting, the reality and the truth that my client, her friends, and her family has been harassed by this victim. They failed to capture that, to have sympathy for. They failed to do that. That the victim had consistently, not one time, not two, not three, but consistently and through various means, not just one way, not just calling on the phone, not just sending a text message, but various means, all kind of ways that she consistently through various means threatened the use of unlawful force against Mrs. Johnson, Miss Johnson and her close friends and her family members. She has harassed all of them, whether it be via unsolicited calls or text messages, is what she said. She said Mrs. Johnson was continuously being threatened by Romika on her cell phone to the extent that Mrs. Johnson had to block Romika's phone number. She goes on to say the threats from the victim were relentless, even having gone so far as to find Mrs. Johnson's grandmother's phone number and then calling her grandmother and making it clear to her grandmother that it was her intent to KI Holly. That it was her intent to KI Holly. The unlawful use of force threatened against Holly by Romika were grave and real. Holly was genuinely concerned for her safety, given she was pregnant at the time that she was receiving these threats from Romika. Receiving threats that Romika was going to end her life and ultimately her child's life. Mrs. Johnson's concern led her to go and obtain an order of protection against Romika, which was initiated in December of 2024. This order of protection was granted in July of 2025, a few months prior to this incident. The victim was served with the order of protection and was very aware that this order of protection was placed against her. See Exhibit 1, copy of OP continuance order noting respondent Blackman was served in open court. A copy of the transcripts for a June 18, 2025 hearing regarding the order of protection was tendered to the court at Mrs. Johnson's initial detention hearing. That transcript illustrated the victim's inherent aggression and hostility, not only toward Holly, but toward the court as well. The court frequently asked Romika to stop. 7 times. The judge asked Romika to stop in court on June the 18th. It said the court frequently asked the victim to stop and that she was not doing anything to help her case of why Holly Johnson needed an order of protection against her. Hence, Ms. Johnson has indeed shown and made clear that unlawful force was threatened against her. So I highlighted here, it says the order of protection was active and served. What the defense says here, Mrs. Johnson obtained an order of protection against the victim. The OP was requested in December of 2024, which I think is order of protection. OP is order of protection. The order of protection was requested in December 2024. It was granted in 2025, served on the victim in open court. The victim knew she was prohibited from contacting or approaching Mrs. Johnson. A court transcript shows the victim behaving aggressively during the order of protection proceedings. Why does this matter? It shows prior judicial recognition of danger. It established the victim violated a court order by approaching Mrs. Johnson. It supports the defense argument that Ms. Johnson feared was reasonable, not speculative, but reasonable. And it undercuts any claim that this was a random or unexpected encounter. Let's continue. Further, the danger of harm was imminent, where Holly reasonably believed that a danger by the victim existed and that the use of force was necessary to avert the danger that the victim presented on the morning of September the 8th, 2025. After having spent the weekend at the residence of her 6-month-old child's father, Carlos Smith, at his address, both Mrs. Johnson and Carlos drove in Carlos's black Mercedes to where Mrs. Johnson was parked, or Mrs. Johnson parked Chevy Cruze, and it had that address. Smith Mercedes was double parked 2 car lengths in front of Mrs. Johnson's vehicle facing westbound on Cermak. In moving her child from the rear seat of Carlos's SUV, Holly placed her child in the back seat of her black Chevy sedan. Why the defense says the threats matter? Let's talk about it for a second. The defense connects the threats directly to self-defense law. They argue the threats established unlawful force was threatened. Mrs. Johnson's fear was reasonable. Her belief that harm was imminent and was informed by history. The victim's actions on that day of the shooting were consistent with prior threats. In other words, what the defense is saying is, this wasn't no paranoia of Holly. This was fear built over time. And the threats plus the day of the incident. The defense stresses that on the morning of the shooting, that the victim allegedly initiated contact, approached Holly aggressively, and did so despite of a valid order of protection. This encounter occurred while Holly was with her 6-month-old infant son. And also that Holly was already under documented fear for her life that was documented just 2 months prior. A court documented that Holly Johnson was in fear of her life. She had documented fear of her life 2 months prior. Okay? It goes on to say the defense argues, this combination made the perceived threat intimate and real, not speculative. Okay? It goes on to say at approximately 8:51 a.m., a white Kia sedan driving eastbound on Cermak is captured on camera making a U-turn facing westbound on Cermak. It says, see Exhibit 2, Sharks external street camera. So they got this from a restaurant called Sharks. Okay? Their street camera picked up Romika's white Kia driving eastbound on Cermak, making a U-turn facing westbound on Cermak. The victim owned a white Kia sedan and used it to drop off her son at school. The son whom she shares in common with Carlos. The victim, which is Romika, blocked. Let me say it again. Blocked Holly Johnson's car by double parking her white Kia on Cermak facing westbound. Now, Mrs. Johnson and Mr. Smith did not invite the victim over. They did not invite Romika to the party. Okay? The victim, Romika, took it upon herself to approach Holly and Carlos in an unsolicited manner. She was not invited. She just popped up. She just popped up. She wasn't texted. She wasn't flagged down. She wasn't lured. She popped up in an unsolicited manner, gets out the car yelling at them saying, I told y'all I was going to catch you. And then it says, see Exhibit 3, Exxon body camera of witness number 1, Carlos Smith speaking to the officer on the scene. So the body cam footage is going to be used as Exhibit 3 to show that Carlos stated this on the scene, that Romika popped up uninvited, unsolicited, jumped out of her vehicle and saying, I told y'all I was going to catch you. Okay. It goes on to say an argument ensued between Holly and Romika. Carlos noted that Holly pleaded with Romika to please leave me alone. Please leave me alone. Please leave me alone. Now, what the motion says about the U-turn. According to the defense, at approximately 8:51 a.m., a white Kia sedan is captured on video. The Kia is seen driving eastbound on Cermak, then making a U-turn. After the U-turn, the Kia is now facing westbound on Cermak. The victim owned and regularly drove a white Kia sedan. After completing the U-turn, the Kia double parked and blocked Holly's vehicle. This maneuver prevents Holly from leaving the scene. The defense emphasized that this was unsolicited. Ms. Holly did not invite or approach the victim. This is all supported by street camera video, not witness testimony or witness memory. This is all supported, again, you guys, by street camera video. Why is this U-turn? Why does it matter legally in this case? Well, first of all, the defense uses the U-turn to establish 3 critical legal points. Let's go over it. Okay? Initiation and aggression. The U-turn is presented as a deliberate act, showing the victim actively pursued the encounter. Not a chance meeting or accidental interaction. No, she pursued them by deliberately making a U-turn and then pulling up on them. This was deliberate. This was no accidental interaction. So this supports the defense claim that Holly was not the aggressor. She did not approach Romika. She did not pull up to the school of Romika's son. She was where she was legally allowed to be. And Romika actively pursued Holly and Carlos. Number 2, intimacy of threat. By making a U-turn, double parking, and blocking Holly's car in, the defense argued the victim created an immediate, unavoidable confrontation, which is essential for a self-defense claim. Number 3, corroboration versus witness stories. The U-turn was caught on video. It does not rely on witness interpretation, and it contradicts the narrative suggesting the encounter just happened. It was by mistake. No, this was not by mistake. This did not just happen. Romika actively pursued Holly and Carlos. The defense highlights this is objective evidence, unlike disputed witness testimony. This U-turn was caught on video. Okay? Let's continue. The state argues, now this is the state now, the prosecutor argues, but we also know that the day that she killed the victim was the first day that she had ever met her in person. And ultimately, if the victim was coming for violence, then maybe any witness out there would have seen the victim attack, either the defendant or witness number 1, and that never happened. So the state is saying, if Romika pulled up on some type of violence, then one of the witnesses would have seen an attack. The defense says, notably, yes, September the 8th was the first time that they was the first in-person encounter between Holly and Romika. But however, irrespective of it being the first in-person meeting between the two of them, that encounter absolutely was enough to cause Holly to be fearful of what the victim could do to her, especially given the victim's history of violent threats against Holly. Again, at the time, Mrs. Johnson had an order of protection against Romika. Romika had previously threatened to KI Holly, had sent numerous threatening and harassing messages to Holly and her family members, and that the victim on that day of the incident was now advancing toward Holly upon seeing her on Cermak with her man that they shared children in common. This was absolutely enough to devastate Romika and make her distraught over the fact that there was another woman in the picture. So right here, the defense is arguing Romika had reasons to be upset and angry at Holly. Therefore, she attacked Holly because she is the new woman in the picture. It goes on to say, witness number one, which we know is Carlos, stated to the police 2 hours after the incident that the victim, Romika, ran up on Holly and swung at her face, making physical contact with Holly. And then it shows Exhibit 3, which is Carlos speaking to the officer, which is body cam footage. The danger of harm was absolutely great and intimate. Holly did not know what Romika was capable of doing, or if Romika would follow through on her threats to KI her previously. The victim, Romika, initiated physical contact. What the defense says here, it says that Carlos told the police that Romika ran up on Holly, swung at her, made physical contact with Holly's face. Why does this matter? Well, it supports that Holly was not the aggressor, 1. Physical contact escalated the encounter from verbal to violent, 2. Illinois law does not require the aggressor to be armed, 3. And this point is critical to self-defense eligibility, number 4. With her 6-month-old child in the backseat of her vehicle, Holly was reasonably proactive and defended herself and her son. Again, given the history between herself and Romika, along with the victim making physical contact with Holly, Holly reasonably believed that the use of force was necessary to avert the danger that the victim was posing to her and her child. Let's talk about that for a minute. The shooter, which is Holly, had a 6-month-old baby present. What the defense says, Holly's 6-month-old child was in the car. Holly was actively transferring her child when the victim approached. Holly was also pregnant at the time those threats to harm her and her child was made. Why does this matter? Well, it heightens the urgency and immediacy of perceived danger. It strengthened the argument that Holly was actively trying to protect her child. Courts give significant weight to defense against taking to protect a minor, and it makes retreat or disengagement less realistic. So when you have a 6-month, or not a 6-month, when you have a child present, the court gives significant weight to that because the court says you're not just responsible for protecting yourself, but you are also responsible for protecting a minor. And then it says, because your child was there, it makes retreat or disengagement less realistic, right? Because you're not just running on your own. You have to secure the child as well. It strengthens Holly's argument that she acted in a manner in which not only protected her, but protected her son. And having a child present, it heightens the urgency and the immediacy of perceived danger. I need to act fast. I need to act quick. Because if I allow a second or two to pass, it may not just be me, but it could also bring danger to my child. Okay? The state has also failed to prove that Holly committed these offenses when improperly relying on uncorroborated witness statements that is not supported by video evidence. What does this mean? Well, let's talk about it. No video of the actual shooting exists. What the defense is saying here: no camera captured the shooting itself, a fist bump afterwards, a door being slammed, verbal threats by Holly Johnson, and neither POD camera nor bus footage shows the shooting. It does not show the shooting. Why does this matter? Well, let's talk about it. It weakens the state claim that proof is evident. It forces reliance on witness recollection, not objective evidence. Detention requires a clear and convincing evidence, not an inference. It helps defense argue the state is building its case on narrative, not proof. The state is using witness statements to build their case. The state is building their case on narrative, not evidence, not proof. There is no evidence that what the witnesses said happened. There is no evidence. Let's continue. When arguing that it has been proven by clear and convincing evidence that the proof is evident and presumption great that Holly committed the offense, the state is only required to present reliable evidence to sustain its burden. Then it goes on and cite People versus Felt. Yet the state is unsuccessful in bringing forth reliable evidence, suggesting that Holly committed the offense of first-degree murder. Essentially, there is no video evidence at all capturing the shooter, either from the pod camera at the intersection of State and Cermak or from bus footage. There is absolutely no video footage capturing the shooting, which means the state cannot say she committed the offense of first-degree murder. You have to understand, self-defense is not murder. So they have no evidence of Holly committing first-degree murder. No evidence whatsoever. Let's continue. Witness 2, 3, and 4 are all independent of each other, which means none of their statements collaborates each other. None of their statements are the same. Not one of witness 2, 3, and 4 saw the same shit. Nobody said the same thing. But all statements, witness 2, 3, and 4. None of these witnesses observed the events on September the 8th, 2025 in its completion, and their statements are entirely inconsistent. Entirely, wholly, altogether inconsistent. For an example, shall we? Witness number 2, last name Woods, stated in his interview video that he drove eastbound on Cermak during the time of the incident to pick up a DoorDash delivery from Momentum Coffee Shop. He says while driving by, he stated to detective that he saw both Holly and Romika on the opposite side from his lane of travel, arguing with Carlos standing in between them. The witness, which is Woods, stated to the detective that he did not see either Holly or Romika displaying any weapon. He further says this witness was not, it further says this witness was not present for the actual shooting. He tells them, no, I didn't see no shooting. I wasn't there. I didn't see that. Woods stated to detectives that he was inside his car driving eastbound on Cermak, turned left on State Street, parked his car in front of the coffee shop, and was inside the coffee shop for 5 to 10 minutes. He was inside the shop when the shots ringed out. The witness further was only able to identify Holly because she was the one that was placed in handcuffs. Not because he saw her with a gun in her hand, and not because he saw her shooting Romika. Only because he saw her placed in handcuffs. That's the only way he knew that she was the shooter. Most importantly, witness number 3. Let's get into this. Hey! Most importantly, witness number 3. Botella is her name. She is the state star witness who sees most of it. But ultimately, what witness number 3 hears and sees is threats being issued toward the victim by the defendant. Here's witness number 1 telling the victim that the defendant had a gun. Heard the defendant making threats to shoot the defendant. This is what she said, right? This is what witness number 3 said. Let me read that again. The star witness who sees most of it, and sees most of it is in quotes because that's what the state said. The state says their star witness who sees most of it. But ultimately, what witness number 3 hears and sees is threats being issued toward the victim by the defendant. Here's witness number 1 telling the defendant or telling the victim that the defendant has a gun. Heard the defendant making threats to shoot the victim. This is what the state says. Yet the statements made by witness number 3, Botella, are wholly, entirely uncorroborated by the evidence where Botella was seen walking in the opposite direction of the scene, crossing a busy street 350 feet away from the scene, had her view obstructed and hindered when she was hiding behind a wall under the bridge of the Green Line, and was seen wearing headphones that would make it difficult to capture an argument from 350 feet away. Let it be known that witness number 3, Botella, headphones are so thick with probable noise cancellation features that the headphones hindered witness number 3 from hearing any outside noise. This is evident by Botella removing her headphones and sliding them around her neck when officers attempt to talk to her about the incident once the officer arrived on the scene. Exhibit 5, which is the body cam footage of the police officer speaking with Botella at the scene. As far as Botella's inconsistencies in her statement and observation, it was approximately 8:51 a.m. on September the 8th, 2025, when a white Kia sedan was seen making a U-turn on Cermak, now facing westbound. Botella is on the 21 bus headed toward the Green Line. So what they're saying here is, at the time Romika did a U-turn, witness number 3 was still on a 21 bus headed toward the Green Line. Botella claimed to the detective that while she was seated on the bus that was nearing the intersection of State and Cermak, she looked to the left of her outside the bus window, saw two females and a male arguing, and that the male was seen by her slamming the door on the female with red hair. Botella also told the detective that allegedly upon seeing this incident of Carlos slamming that door, slamming the victim with the car door, she exclaimed, "Oh my God," as she was talking to her boyfriend. False is what the defense attorney said. False. Such events of her exclamations are not captured on video footage from the 21 bus that she was traveling on. What does that mean? That means that attorney Ari went and solicited the video footage from the inside of the bus camera and saw that witness number 3 was wearing headphones. Only looked to the left for a total of 9 seconds. It says at 9 a.m., 9 minutes after the Kia is seen making the U-turn on Cermak, the video footage from the bus capture witness number 3 seated on the left-hand side of the bus with a stroller in the front of her. So she had her baby in the front. She is seen wearing headphones covering up her ears. As witness number 3 is seen briefly looking out the left side of the window at the scene for a total of 9 seconds. Witness number 3 turned her head forward, facing the front of the bus, and continued her ride. Botella had no reactions on her face whatsoever as to the body slamming that she claimed that she just witnessed Carlos do to the victim with the victim's car door. On that note, the video footage from the bus does not capture Carlos hitting the victim with the door. So there is no video footage from the bus, inside or outside of the bus, does not capture Carlos hitting Romika with a car door. It doesn't show that. It does not capture what she claimed it did or what she saw. Additionally, witness number 3 is not exclaiming anything, making statements of any kind. This is on the camera. She is not holding a phone, nor is she talking to anyone near or around her. Her mouth is not moving whatsoever. Instead, she is unaffected by the events. There are 9 minutes of the event that witness number 3 did not see. She did not observe how the event began, nor any of the threatened behavior by the victim toward Holly. Even then, the bus never made a complete stop at the intersection of State and Cermak. The bus never stopped, you guys. Never stopped. The bus just cruised on by. The bus continued moving eastbound on Cermak, driving through the light. It did not stop at the light. It drove through the light. Once the bus drives past the intersection and approaches its stop, witness number 3 gets out of the bus with her baby stroller and continued to head eastbound on Cermak. See Exhibit 7, bus footage with evidence that showed she walked away from the scene, not toward the scene. It says witness number 3 is traveling in the opposite direction of the scene and proceeds to do so, missing much more of the event between Holly and Romika. Witness number 3 further alleged she was able to hear Holly and the victim yelling at each other while she was on the bus. This is refuted completely, where witness number 3 is wearing large, thick headphones over her head. Such headphones would make it impossible to hear exactly what was being said when witness number 2 and number 4 was unable to hear exactly what was being said. Again, witness number 3, headphones hindered her from hearing anything or any outside noise. This is evident, again, by her removing her headphones and sliding them around her neck when the officer attempted to talk to her in her damn face. And this is caught on body cam footage. She couldn't even hear the officer that was standing right in front of her, but she claimed she heard what was going on while she was on a bus with headphones on that never stopped, that continued to move through the traffic light. But yet she wants the state attorney to believe that she heard the arguments while sitting on a bus, a moving bus with headphones on. It goes on to say, even once witness number 3 was out of the bus, turning around and crossing Cermak to get to the sidewalk near the other lane of traffic, Botella was approximately 350 to 400 feet away from the scene. See Exhibit 8, a map showing the distance between the scene and the green line. Not only would she be too far and too distant to hear the exact words coming out of Holly and Romika's mouth, but Botella also was too far to clearly see what the hell was going on. This is evidence, y'all. This is video footage, you guys. She did not see and hear what she claimed she saw and heard. In the same sense, Botella's view was also obstructed numerous times by a wall while she was making her second 911 call at 9:04 a.m. Botella is seen emerging from behind a building while she is under the Green Line Bridge that is outside the view of the scene. See Exhibit 9, POD camera. POD camera, it may not have caught the shooting, but it damn sure caught witness number 3 ducking behind a wall and under the Green Line Bridge that is outside of the view of the incident. She is on camera. She is caught on camera. Nowhere near the scene. Further, the state fails to take into account the lack of credibility from the witnesses' stories to which they are relying on. The state alleged that Botella, which is witness number 3, also observed witness 1 and the defendant fist bump each other after the shooting. Not only is the fist bump not captured on pod camera, but witness number 3 never mentions or exclaims such a thing occurred while she was on the scene, which means that she came and added that shit later. That fist bump, yeah, she added that later. State star witness was on a moving bus with headphones on. What defense is saying? It says witness number 3 was on a CTA bus wearing large headphones, approximately 350 to 400 feet away, had an obstructed view, was moving away from the scene. Video shows no visible reaction, no phone conversation, no exclamation. Bus footage contradicts her claim observation. Why does this matter? Well, it directly attacks witness number 3 credibility. Sounds like she's just a big fat liar. It undermines the claims that she heard threats and saw key events. She didn't see shit. It weakens the state's timeline. And courts cannot detain based on unreliable eyewitness testimony. This just shows that Attorney Ari just discredited the fuck out of witness number 3. Witness number 3 lied. Straight, bold-faced ass lied. And it was caught on video. It was all caught on video. On video. This bump claim is unsupported. What the defense says here, the state alleges a fist bump between Holly and Carlos Smith took place after the shooting. No video shows this. Witness number 3 never mentions this at the scene, and no officer documented it at all. Why does this matter? Well, let's talk about it. The first bump narrative suggests celebration or malice intent. Without proof of this fist bump, it becomes speculative and prejudicial. Defense uses this to show the state is embellishing. Embellishing. That means they adding shit. They dressing shit up. They're putting sugar on top of shit. They are embellishing. The state is embellishing. And it undercuts intent and state of mind arguments. The fist bump was not caught on camera. And it only was seen by the lying ass witness number 3. Let's continue, shall we? Additionally, witness number 4. I don't even know why witness number 4 is even a witness, but let's talk about it. His last name is Dorsheys. Additionally, witness number 4, Dorsey, statement to the detectives on the case is completely unreliable and not credible. I agree, Ari. Girl, speak your shit, baby. Speak your shit, baby. It's not even credible. It's unreliable. Dorsey is a crossing guard for the National Teacher Academy, which is located just across the street from the incident. Dorsey did not observe Holly shoot the victim. Dorsey is simply assuming such is the case. When asked by detectives why he believed the victim was shot by Holly, Dorsey, out of his own mouth, claimed that just because of the fact that she explained, from what I heard, she explained that she had a conceal and carry. So I just figured that her saying that is basically letting me put 2 and 2 together. Yeah, this is his statement, y'all, word for word. Basically letting me put 2 and 2 together, and she actually was the one that pulled the trigger. See Exhibit 10. Mr. Dorsey's statements are based on hearsay and interference that cannot be taken for their truth. He literally said in his statement that he just put 2 and 2 together. He's saying, I ain't see her shoot her, but I mean, I heard her say she has a concealed and carry, so I just put 2 and 2 together and just assumed that she was the shooter. He said he put 2 and 2 together. Let's talk about it for a second. Witness number 4 statement is based on assumption. What the defense says here. Witness number 4 did not see the shooting. He assumed Mrs. Johnson shot the victim because he heard she had a concealed carry license. His belief is hearsay plus inference. Why does this matter? Assumptions are not evidence. Courts cannot rely on speculation to justify detention, and it weakens the state multiple witnesses narrative. Multiple witnesses narrative. Multiple witness narrative. Yeah, well, it eats it up. It goes on to say, where Mrs. Johnson has not been convicted of any of the offense alleged in this case. Convicted, you guys, not charged, but convicted. Mrs. Johnson has not been convicted of any of the offense alleged in this case. Mrs. Johnson has a presumption of innocence, meaning that she is innocent until proven guilty. So she has a presumption of innocence. No evidence has been presented in this case that would rebut Holly's presumption of innocence to meet the state's burden here. She's saying, the attorney Ari is saying, the state ain't got no MFing evidence. No evidence. They have not presented any evidence, not one piece of evidence that would rebut Holly's presumption of innocence to meet the state's burden here. All the evidence presented to potentially incriminate Holly is circumstantial and cannot meet the state's burden. Which means they relied heavily on witness statements. It says, where the state fails to meet its burden of proving by clear and convincing evidence that the proof is evident and presumption is great, Holly, in fact, committed the offense she is being charged with. The court should release Holly from pretrial detention. The state cannot meet its burden of proving by clear and convincing evidence that Holly Johnson possesses a real and present threat to the safety of any person or the community. The state here cannot meet their burden of proving by clear and convincing evidence that Holly poses a real and present threat to the safety of the community. The circumstances and facts of this case do not weigh in the favor of any of the factors the courts considered when determining whether a defendant poses a real and present threat to the safety of any person. A court may consider the factors articulated in 725 ILCS 5110-6.1, in addition to the specific articulable facts of this case. When determining whether a defendant poses a real and present threat to the safety of any person, amongst these factors are the natural nature of the offense, age, and physical condition of the defendant, whether the defendant has access to a weapon, and any factor deemed by the court to have reasonable bearings on the defendant's propensity for violence. And then it goes on to say, in the present case, while the charge being brought upon Holly is of a violent nature, no evidence, none whatsoever, has been presented that Holly did in fact commit these acts. Y'all ain't even proved that she did this shit, let alone poses a threat to the safety of community. You guys have not proved that, is what the defense is saying. Holly has no violent background. She has a misdemeanor retail theft from 2014 out of Lake County, receiving suspension for that. She also has a prior misdemeanor conviction from 2015 for speeding. Ooh. But Holly has no pending cases at this time. Defendant has no violent history. What the defense says here is only prior records show a misdemeanor theft and a speeding misdemeanor charge. No violent offenses, no pending case. Why does this matter? Well, it refutes the claim that she poses a real and present danger. It supports the release under Pretrial Fairness Act. and it shows the incident is out of character for Holly, not a pattern. This is not the character of Holly Johnson. This is not the pattern of Holly Johnson. It says where the state erroneously argues that Holly is a risk and was emboldened by carrying her firearm, such is not the case. The state fails to see the gravity of harm posed to Holly when confronted aggressively by Romika. Neither was this a twisted sense of self-defense. Holly and her 6-month-old child was in harm's way on September the 8th of 2025. Holly should not be punished for being legally permitted to carry a firearm for protection and using it accordingly. Neither did Holly Johnson fire multiple times at her with a pause between the first shots and the subsequent shots as alleged by the state. Rather, it is alleged that there was 3 shots in the beginning and 2 shots afterwards with 10 seconds in between each shot. See Exhibit 6. The witness 3 statement said that, right? Botella said that. She said it was 3 shots in the beginning and 2 shots afterwards, and then it was 10 seconds between each shot. The defense said that shit did not happen. The defense said it's a lie. The defense said there was no 10-second pause between each shot. And you know the beauty of this? The beauty of this is because the shooting was not captured on camera, it is solely up to the state to prove that there was 10 seconds between each shot. Holly and her defense team don't have to prove that. They said it didn't happen. The state have to prove that it did. The burden of proof is on the state to prove that it did. Actually, the burden of proof is on the state to prove all of this shit. Holly do not have to prove anything. The only thing that they have to do is raise a self-defense claim. Once the self-defense claim is raised, in which it will be guaranteed, they don't have to prove nothing else. Nothing else. They don't have to prove that Holly was scared. They don't have to prove that, well, let me take that back because that's part of the self-defense claim. But they don't have to prove that the gun jammed or didn't jam. They don't have to prove that there was 10 seconds between each shot. They don't have to prove anything. The state have to prove otherwise. Otherwise. Okay, let's continue. Again, it says, rather, it is alleged that there was 3 shots in the beginning and 2 shots afterwards with 10 seconds in between each shot. See Exhibit 6, Witness 3 statement. Again, this proved that the incident that took place on September 8th was not done as a result of Holly Johnson's character for violence, but out of a need for protection and self-preservation. Holly is a mother of 1 and is also currently pregnant with her 2nd child. Holly was about to begin dental school. Prior to that, Holly had a successful lash business. She is not someone who is at risk of repeating this offense against any of the witness nor the community at large. Holly is known to be a loving mother and devoted daughter who has contributed tremendously not only to her household and family unit, but to her community, having donated food and supplies to shelters for women and children while also volunteering at homeless shelter, which it shows exhibits with character letters. She is known as being an anchor within the Johnson's family, an asset in her family and within the community. Other character letters. Ms. Johnson is grounded in her family values, driven by generosity, compassion, and willingness to serve others. Another character letter. And it says, on her PSA, Mrs. Johnson scored a 2 on the new criminal activity scale, a 2 on the failure to appear scale, and her PSA score coincide with level 3. Let's talk about that. Pretrial risk score does not recommend detention. What the defense is saying here, PSA score is low risk of new criminal activity, low risk of failure to appear, and level 3 overall. Why does this matter? Basically, it's saying objective risk tools contradicts the state detention argument, and courts are expected to consider the PSA result. Supports use of condition instead of incarceration, which means that it supports her being released to home confinement, ankle monitoring, and other conditions as they see fit, but not incarceration. Her PSA score basically says she does not deserve to stay detained until trial, is what her PSA score says. And the courts must abide by that. But let's continue. Mrs. Johnson is not a threat to the safety of any person or the community, and the states will not be able to show by clear and convincing evidence that Holly poses a threat to the safety of anyone, based on the articulable facts of this case. The courts cannot determine, based on the evidence presented, that Khadijah Johnson is at risk of failing to appear at future court dates, and that no combination of condition can mitigate her willful flight, meaning that she ain't no damn flight risk. If that's the case, she would have been left. She would have been gone. A court may only deny pretrial release if the defendant fulfills one of the 6 categories. I think I went over that already. And she don't, okay? Which means they must release her. But let's continue. Let me skip this already, because it gives a whole bunch of citing cases. All right, now it goes down. It says, further, simply believing that Holly would be incapable of complying with electronic monitoring and referencing the way that electronic monitoring is set up, finding that there were theoretically possible ways in which pretrial suspension might fall short of clear and convincing evidence that no condition can mitigate the threat. Additionally, the state has failed to provide any evidence that Holly either resisted arrest, attempted to evade prosecution, or had any history of missing a court hearing. The state cannot argue or present any history of attempts by Mrs. Johnson to evade prosecution, nor has the state acknowledged any of the potential mitigation factors listed in Section 110-10B. The state is simply making allegation and proffers about the facts of the case and the defendant's criminal background. Holly has no other violent history beyond the current case, and the record before us demonstrate that she has otherwise been an upstanding and law-abiding member of the community. If the court still had concerns about Holly appearing for future court dates or engaging in criminal activities, Holly could be placed on home supervision or electronic monitoring. Placing Holly on electronic monitoring or home detention would allow the courts to inspect, direct, and evaluate Holly's compliance with the terms of her bond condition. And then it goes on to say, wherefore defendant Khadijah Johnson respectfully requests that this honorable court vacate its order for pre-trial detention. They basically saying, get rid of it. Throw it out. Throw your pre-trial detention order away. Now, as we finish this one right here, the defense isn't relying on emotion. They're pointing to court orders, video evidence, risk assessment, and witness contradictions to argue that continued detention does not meet the legal standard. Now, I believe that Attorney Ari did a hell of a fucking job with this motion, and I believe 100% that she will be released off of this motion. Basically, in a nutshell, it shows the state ain't got no motherfucking proof. No evidence whatsoever. The state has no proof. At this point, they don't even have no proof that Holly was the damn shooter. But they most definitely don't have no proof that it was done intentionally, with malice, without legal justification. They do not have any proof of that. This will be an uphill battle because without video evidence, everything that any witness have said will have to be proved, not by the defense, you guys, but by the state. The state will have to prove that anything that Carlos or Holly says, I'm really going to just say Holly because, let's just say Holly. Anything that Holly says, they have to prove that it's not true. They have to prove that her fear wasn't reasonable. They have to prove that it wasn't intimate. They have to prove that she could have retreated, moved away, or did anything else. Okay? They have to prove that. So the fact of the case right now, as we know it right now, there is no evidence that backs up a first-degree murder charge. I do believe that they would try to lower it either on January the 7th or soon after. I do believe that they may seek other witnesses because the 4 that they have now, well, really the 3, is water. Especially number 3, their star witness is going to be creamed. But I hope that they don't throw her out right now. You know, I hope that it actually goes to trial. If this case goes to trial, I hope that they allow this witness to go because she's going to look real bad in front of the jury when questioned by the defense attorney. She will be ate alive. Okay. They have to prove that her shooting Ramika was not justified, legally justified. The state has to prove that. Holly is not responsible for proving that it was justified. No, they got to prove that it was not justified. That's what a lot of people miss. A lot of people think that the defense attorney have a lot to prove. In fact, no, they don't. No, they don't. It's actually the other way around. The state must prove that it wasn't self-defense. The state must prove beyond a reasonable doubt, mind you, beyond a reasonable doubt. And as of today, there is a lot of reasonable doubt. A lot of reasonable doubt. So if they had the case today, Holly would be set free. She would have a justified homicide. Now, I don't know if they're going to pull other evidence out their asses. I don't know that. But if this is all they have, if this is all the evidence that they have, then they are doomed. They are doomed. They have nothing to back up anything against what Holly says. And people don't understand that. You got to understand the placement of the body was right by Holly's car, right? Right by Holly's car. So the fact that shows right there that she advanced toward Holly. Holly didn't advance toward her. The body dropped right by Holly's car. All the lies that has been told thus far by a lot of creators, because they put this bullshit out there. Well, the witness did it first. Then the creators took it and kind of embellished it, right? But all the lies told that the body was moved, drugged, and all this bullshit, that she wasn't blocked in, she could have gotten away. All lies. And that was caught on video. That's on video that she was blocked in. See, the photo that they tried to show later was after Carlos had already moved his vehicle. Well, the CTA bus actually caught the vehicles very close to each other to where Holly could not move. Holly was blocked in by Ramika. Ramika pulled up and blocked her in. And it's evidence, video evidence that shows that will be shown in court. Now, I'm pretty sure witness number 3 didn't realize that the things that she said was going to be double checked. I'm sure she didn't realize that. She's only 20 years old, a young girl. She did not realize that they were actually going to check her out. And they did, to the point of they pulled the video footage from inside the bus, y'all. Inside the bus. They tracked her every move. She is the star witness, you know. They tracked her every move. Every move. So all of this, Holly ran up and banged up, none of that. It was all lies. The witness number 3 lied. She lied. Straight up ass lie. But the state used this witness statement to build their case. That's what they did. They used the witness statements to build their case. They have no other evidence whatsoever besides the video footage that shows that the witness didn't see what she said she saw, and they have the video footage that shows that Ramika did a U-turn and pulled up and blocked Holly in, deliberately pulling up on them, not them on her. So a lot of lies is being dispelled, and they will hear this on January the 7th. So I do believe that she will be coming home. So for those that are upset and saying that she ain't never coming home, well, you might as well just get used to it, because the 7th is right around the corner. I think it's like less than 9 days from now, 10 days. So I do believe that she will be home within the next 10 days and whatnot. So you can cancel Martin Luther King Day or something for that one. All right. Any questions? She said that girl pulled up on demon time and the consequences ended up being her death. You're absolutely right. She pulled up on demon time. She pulled up on demon time. She said, you can get Holly off. What do you mean you can get Holly off, Stephanie? She said, miracle, because there's video proof that she's lied. Absolutely video proof that she lied. Absolute video proof that she lied. She said, how you going to say that witness lied? What the hell? She did. Video proof. Video evidence. I didn't say it. Video evidence said that she lied. Video evidence said it. She said, where's the video? Did y'all see it? It's all throughout the document. The attorney cited it. It's going to be shown in court, sweetheart. It's going to be shown in court. But go there on the 7th. You might be able to see it too, because they're going to show it in court. They're going to show it in court. Okay. She said, I'm not sure how she does. I mean, I'm not sure. Well, I sure hope she does come home to fight this. Prayers to her. She's definitely coming home on the 7th of January. She's definitely coming home. They have absolutely nothing to hold her. Absolutely nothing. The fist bump was all a lie. And that's what got her to stay in the first time. That shit was made the fuck up, and they have no video footage of it whatsoever. The state attorney literally just relied on a 20-year-old lying-ass witness to say that there was a fist bump. Nobody's seen that fist bump. And for all the liars that came out and said they actually seen the video, shame on y'all. Shame on y'all for saying that y'all saw that video. Shame on y'all. Shame on ya. You should be ashamed. You had me believing you. You had me believing that there was really a videotape out there where they fist bump. How you lie? Don't come in over here with those lies. Cut that shit out. Don't do that. Y'all came over here like y'all sink the shit. Y'all ain't sink shit. Because if you have, you would have got it to the state attorney. The state attorney would have had it as evidence. Cut it out. She said, so you honestly think she was locked up for hearsay? 100%. Well, let me just say this. Let me correct myself, Miracle. Unless they are hiding other evidence, unless they have not given over all the evidence, which I believe by law, they have to, right? So unless they are holding other evidence, then yes, I believe that she was absolutely locked up over hearsay or detained over hearsay. Now, let me correct myself. When I say locked up, I mean continued detainment. Because no, I'm not going to say she was locked up over hearsay. They could have locked her up when the shit first happened, but they did not, because they said they didn't have substantial evidence. So let me correct myself and say they could have locked her up, right, from the beginning. However, given the circumstances of the restraining order, the fact that she had a license to carry, and the fact that they said that Romika attacked them, they didn't have sufficient evidence to lock her up. So they said. I believe that they did, but they said that they did not. But now they're trying to say the fist bump is what's keeping her detained. So yes, I think the hearsay of the fist bump is what kept her detained. I don't know if that's what you meant. So she said, FYI, the state has, I said before, will pick up cases they know that they can't win for political reasons. Sister teacher, girl, people ain't gonna like that you say that, but hey, it is what it is. You know what I mean? She said Romika started it by making a U-turn and exiting her car to fight Holly. Yep, she was on demon time. But I did have 2 people so far jump in my inbox to tell me that they were Romika supporters and that they are now seeing things differently, that more information is coming out. And like I think I was talking to David today, I said the fact that people are actually seeing things differently. See, people was just they was looking at one side of the story. The defense hadn't even put their story out there. They literally just went by these witness statements and just believed it. They don't realize that witnesses can lie, which this one did real bad, right? However, I kept saying the defense have not said their side of the story. The defense have not made a statement. We gotta wait, we gotta see. But people took off and they ran with it. And now people are like, whoa, hold on, wait a minute. You mean there was no fist bump? Whoa, hold on, wait a minute. You mean there was no video footage of the shooting? Whoa, hold on, wait a minute. You mean that there's video footage that proved that witness number 3 lied? That witness number 3 wasn't nowhere around the scene when the shit took place? Wait a minute, what are you talking about? What are you talking about? Okay? You mean to tell me that was a lie? You mean to tell me that witness number 3 didn't actually see what she said she saw? She was ducking behind buildings and shit. What? You mean to tell me for 9 minutes of the incident, she wasn't nowhere to be found? You mean to tell me that she was 350 to 400 feet away at best? You mean to tell me this? And so they're realizing that that witness fucking lied to the damn public. She says, oh my, did Q lie? Q lied. He ain't seen no damn video. He lied too. He lied. She said, and you cannot lie because you have to have proof about everything. These people can pull up old text messages from years ago. Trust me. Oh yeah, she has them. Attorney Ari has a stack of text messages, not just text messages, you guys. See, a lot of people don't know this. It wasn't just text messages and phone calls. She literally jumped in this girl's inbox and sent video footage of her going off on Holly and threatening to unalive Holly. That's what a lot of people don't understand. Now, unfortunately, I may not be able to go to trial when this happens, but people in court, they wigs gonna be flown back when they hear Romika did the ultimate. She jumped in this girl's inbox and threatened her. It wasn't just no text messages. It wasn't no, oh, Holly just made this shit up herself. No, Romika threatened this girl. She legit threatened this girl in multiple ways. In multiple ways. But this shit is going to be seen in court. This ain't even for it to be played out on the internet until it's seen in court. Once it's seen in court, then I'm sure people will get a hold to it if the court allows cameras in there, and then they will play it then. But You're right. There was no headlock. No video footage of no headlock. No video footage of no body slamming. Let me tell you something. All those people that were saying, lock Carlos up, lock Carlos up, lock Carlos up. The state ain't got no motherfucking reason to lock Carlos up. You want to know why? They ain't got no proof. They know witness number 3 is a liar. They just didn't know they was going to have a bomb-ass defense attorney to prove her ass a liar. The state know that witness number 3 is about to be grabbed by the scalp of her head, the nape of her head, baby. The state attorney already know that. But they probably thought that Holly wasn't going to be able to afford a good defense attorney. This defense attorney is getting ready to dog walk witness number 3, and I'm all here for it. She needs to be dog walked. Anybody that can come forward and make up lies in which she did that threatened someone else's livelihood when she didn't know what the fuck was going on. She didn't know the history. She didn't know that Holly was being tormented and harassed and threatened by Romika. She didn't know that. She didn't know the hell that Holly had to endure while carrying her baby due to Romika. But she embellished, made up all these goddamn lies. Yeah, no, she needs to be dog walked. And I am here for it. I am here for it. So I hope she does go to court. I hope that the state continue to use her as witness number 3, the star witness. Because, baby, I'm here for the defense. Cross-examining that ass. So the jury can hear that this bitch wasn't even on the scene. That this girl did not see what she say she saw. Did not hear what she say she heard. Made up shit. I saw her eyes and I looked into her eyes and I said, no, this cannot happen. We got to go help her. Let's go help her. Now, let me tell you, people should be outraged that this witness lied and got everybody in their feelings, got their panties all balled up in a dirty knot. People should be outraged. But I guarantee you that there's going to be some people that's going to try to defend her. How you going to defend video footage? Video footage says she lied. Video footage says she wasn't nowhere around when this shit went down. This lady gave play-by-play like she was standing out there sucking on a popsicle or something. You hear me? This bitch all over the place. She got a baby with her. She got headphones on her ears. She's on a damn bus, ducking behind buildings, crossing the street. Girls, this girl was everywhere. She was everywhere except for the scene. Except for the very end. When the police pulled up and all the ambulance trucks, that's where she was. She pulled up after the fact. After the fact with her good line ass. After the fact. And I do not feel sorry for her. And I don't give a fuck who does. I really don't. If you can lie like this, then you can do much worse. If you can lie like this, then you are capable of doing much worse. Hey, what's going on, David?
Hey, like my headphones?
Oh, I see your headphones. Can you hear me with them damn headphones on?
Not really.
Try being on a bus on the opposite side of the street, baby. This is crazy, ain't it?
It's crazy work for real.
It is.
Hold on. I gotta. God damn it. I gotta get
Absolutely crazy.
I gotta get into my big keys mode. Hold on. Yes, CCL. Just restraining order. You're going to jail. Carlos, you're going to jail. It's big keys. Keys against the world. You're going to jail.
Wait a minute, what Lakeisha say? She said, get the report or more if you're going to defend her. What are you talking about? I have no idea what you're talking about. Report or what? Get what report, Lakeisha? I'm not defending her. I'm not getting paid the big bucks, sweetie. But I am going to do commentary on the entire thing, if that's what you're saying. I'm not defending her. She got a bomb-ass attorney. I wouldn't want to replace her bomb-ass attorney. Her attorney going to eat witness number 3 to fuck up, though, and I'm here for it. I'm absolutely here for it. She says, Amor, please have a virtual party when this is all said and done. You already know I am, child. You already know I am. She says, I think lying witness should be charged for tampering with. Now, I don't even know if that's the case. I said I was going to look it up, but I need to. Now, I know a couple of you Ramika supporters, Justice for Ramika, are upset. And hey, rightfully so, be upset. Because you always believe in one side of the story. It's okay to be upset. That's a natural feeling. Go ahead and get it out. Be mad. It's okay. Look at your locks. They look all fresh. I see you. I see you.
With my fat ass forehead, looking like Pennywise over here, but whatever.
Oh, they said you look like Pennywise. Who said that?
Key said I look like Pennywise. He zoomed in. He zoomed in on I think this part of my forehead right here.
Mm-hmm.
I can't
How can
help
Keys talk about the way anybody look?
I can't help the way shit. I was born shit. I got my daddy forehead. Well, 5 head.
I know.
I got
people be.
I got
I
my
know.
daddy 5
People be tripping. They be acting like you can control the way you look. I look like my mom and my daddy. Shut the fuck up. It is what it is.
Look, I got all my locks are intact. Shit. Got them.
All right, somebody just said to me, they sent me a message and said, what?
I ain't lost no locks. Shit.
It says, I don't want to ask this question in the chat because I don't want it to seem messy, but was there an autopsy online regarding Romika saying she was actually choked? I saw platinum bracelet in Jenny's live telling her that she was going to send the information to her. That's why I'm asking, because I never heard that. No, it didn't say she was choked. I think it did say that she had like something around her neck. But that doesn't matter. She could have been choked the night prior having sex. There is no video footage that a choking or anything took place. So they can't, the state would have to prove that she was choked. She could have been choked the night prior while having some rough, tasty, divine sex, baby.
She did say she had just got cracked like an egg.
She did say she got cracked like an egg. So, I mean, they can't prove that unless they got video footage, they cannot prove that a choke took place. And no, the autopsy report that I read did not show anything about a choke. I think it did say she had something around her neck though, but it did not say.
She had a swollen, what's this right here? I forget what it is.
Thyroid or something?
Thyroid, yeah, she had a swollen thyroid, but what if that swollen thyroid came from her choking on blood, as she was choking up blood?
Oh yeah, that's true too. So yeah, that proves nothing. So honey, don't believe the lies. Don't believe the lies, baby. Don't believe the lies. She said the choke was the headlock. That was proof. No proof, baby. It's not on video.
That headlock
no video.
Came from witness number 3, and we not believing shit that bitch said.
Yeah, because witness number 3 did not see what she said she saw.
She said, and even in her statement, Amora, she said it was what looked like a headlock. What looked like a headlock, or it was a headlock.
So sister teacher said, and I didn't know this, the sister teacher said, the witness has not been sworn in. She has the opportunity to retract her statement before trial to prevent prosecution on herself. The state won't move forward then. Oh, okay. I didn't know she had an opportunity to retract her statement. But now that she knows that that her ass is caught on camera, not where she claims she was at the time of the incident, I'm pretty sure she will retract it. She said the truth is getting out, like Carlos said. You right about that? The truth is coming out. The truth is coming out. The truth is coming out. So she said Keys can't talk about nobody. Yeah, he can't talk about nobody. She said when he one fry away from what? From diabetes with his big sloppy ass. Oh Lord.
Dude, you saw how what's her name just had they said I think she had multiple cardiac arrests. The Big Brother
Oh,
star, the 35-year-old girl, and she was in shape.
she said I was a Ramika supporter based off the news report. I changed once I researched myself. I've had two people, which I won't out them or anything, that jumped in my inbox and told me thanks for bringing the truth, that they was a Ramika supporter until this new evidence came about. They actually thought that it was a real fist bump, and they actually thought that the witness number 3 saw what the fuck she said she saw. But when they just found out that witness number 3 did not see what she said she saw, did not hear what she said she heard, they are no longer supporting Ramika. And I'm not even trying to change nobody's mind. You change your mind if you want to. I'm not even trying to change nobody's mind. Just follow the evidence, baby, not the emotions. Follow the facts and the evidence. Video footage is facts. Video footage is evidence. All this hearsay, she say shit is speculative. Speculative lose cases. Speculative lose cases. That creates reasonable doubt. Okay? Speculatives creates reasonable doubt. She said, y'all really believe anything people say? No, we don't. Other people do. If Holly didn't shoot, did? Who
Nobody
did it?
said she didn't shoot.
No one says she didn't shoot. It says that the state is saying it was not justifiable, that she committed murder. And what the defense attorney is saying, that it was not murder. She did not commit murder. There is no proof that she committed murder. You have to understand the words. That it is no proof that she committed murder. It is not murder. It is a justified homicide, is what she's trying to say. She's trying to say it was self-defense, not murder. She said street justice for Ramika. Well, it might be street justice because that might be the only way you're going to be able to get some. Just being honest with you. She said, I have never been a Ramika supporter. Something in my spirit. Hell no. Ramika got some shit with her. What LaConda say? LaConda says, I think we can agree that we wish Ramika was still here with her son. No one is happy about her being gone. It's truly sad. Yep, that's true, LaConda. No one is happy that she's gone. She was just on some demon time, though. She says that's why she didn't want to testify in court, because she knows she's lying. Yep, I agree with you. She said lying in court, you can go to jail. You can, but that's what Sister Teacher was saying, that she could retract her statement before going to court. I'm pretty sure that girl didn't know she was being filmed on the bus. Come on, to be honest. Did you know there was cameras on the bus? Because I didn't. I ain't never rode no bus like that before. But would you
Yeah,
think that there was?
they
Oh,
got
you
them
see
on.
the camera?
Yeah, they got them on CTA. They got them on the trains. That's why, like, we got something up here called Legal Help Firm. If you go on they page, they got like clear pictures of people that do crimes on like the buses and the trains up here, and it'd be like police are seeking help identifying these people that did this robbery on 69th Street, red line stop, or some shit like that. They got clear ass cameras.
Well, let me ask you this. Do you think that, I know the girl is young, she's 20 years old. Maybe she wasn't thinking, but do you think that she thought about the defense attorney gonna go pull the video footage of her being on the bus?
Nah, I don't think she thought that they was gonna pull that footage.
Yeah, I don't think so either.
That's
I
probably
don't think.
why. That's probably why the boyfriend ain't give his statement.
Well, I learned that a boyfriend and girlfriend statement, because they are boyfriend and girlfriend and they admitted it, it only counts as one witness.
Oh, okay. So
You can't
basically,
count it.
whatever she say is what he says.
Basically, yeah, they can't do it separately, because it'll be like they work together to come up with a story. So there's no, out of the 4 witnesses, none of them say the same thing happened. I mean, none of them collaborate each other. They're all inconsistent, and inconsistent witnesses are just not good for a defense. I mean, for a state, a case.
Well, shit.
Oh, wow. Riri says CTA buses have a total of 17 cameras on them. Did not know that information. Wow. That's crazy. For her to not think that she was going to be recorded. But she's young, so probably wasn't even thinking that on that level.
That means they can see up my big ass nose. Shit, you got 17 cameras.
All right, so Yellow Blossom said, did Carlos or the defense explain how it went from him standing in between them to him moving from Ramika to be unalived? I think he did explain that. He said he went to go move his vehicle out the way because he finally talked Romika into leaving, getting in the car and leaving. So she agreed and said that she was going to leave or whatnot. So he went to move the car up so that she can get out, right? And as he went to go move the car up, while he was in the car, he had only moved it a little bit, and she jumped out the car and rushed toward Holly. By the time he caught up with her, it was already too damn late. She had swung on Holly already. So she knew what she was doing. She wanted a lick or 2 or 3 or 4. Where is the proof the witness lied? Stop believing anything. The proof is in the video, sweetheart. It's in the statement. It actually says there's video footage to back this up. But you stop believing everything. You actually believe that the witness told the truth with no evidence. Make that make any sense? Exactly. Make that make any sense? You sound ignorant. Very much ignorant. You believe the witness with no video footage, but you don't want to believe that the witness lied with video footage. Make that make sense? Let me close my blind. It's getting dark over here. She don't want to believe video footage, but she'll believe a 20-year-old.
They think the witness is Honest Abe. Shit.
Yep. They'll believe the video. They'll believe the 20-year-old witness with no video footage whatsoever, no evidence.
She just had too much passion in her voice. When she said the word nigga, I felt that. I felt that shit through the phone.
Well, the thing of the matter is, they want to believe. She said, "You don't know what I believe because you don't know me." Well, I know a little bit. I know that you don't believe video footage.
Well, you know what? We don't know you. You don't know Carlos. You don't know Romika. You don't know Holly. You don't know none of them. But yet you still chose a motherfucking side. So fuck you.
She said, how am I a troll when I said if I had my baby, meaning the witness, I wouldn't be out there with my child trying to witness nothing. I know, child, I would have had my baby. And listen, she had her baby, y'all. There ain't no way I'd be out there with no damn stroller trying to say, oh, let me see what's going on. I heard shots. Let's go over here.
I said that, but nobody wanted to listen to me when I saw the video, saw Travel Island tried to cover it up with that emoji, that big emoji, that loud talking emoji. I said that lady was out there on the scene with her baby in a stroller. But no, nobody wants to believe me.
She was not there. This person is not telling the truth. Our young blood, she was not there. Is already video proof that she was not there. Video footage shows that she was not there. No matter what you say, video proves that she wasn't there. Say whatever you want to say.
I got to get back into character.
Keys knows the truth. I don't have to explain anything to you. Keys knows.
Yeah, I know the truth. Big keys against the world. How's my hat?
Yeah. No, this person is like, she was there. She was there. Well, video footage says she wasn't. Now go get mad at the video footage.
That video's AI. The lawyer made it. The lawyer made the video that came from the state themselves.
Go get mad at the CTA footage, okay? Go get mad at that. She said, you're speaking from hearsay. You have never seen any footage. It says it in the attorney said that there's footage. Are you saying the attorney is lying? Young, are you saying the attorney is lying? Why would the attorney say in her statement and then put exhibit such and such for the video footage? Are you saying that she's lying?
Exhibit
You
means
guys
that
are. Ooh,
when
child.
when they
What's
say
wrong?
exhibit, that means they're offering that in as evidence.
Exactly. Do you not understand that? And they got video attached to it. Huh? What are you talking about? They got video attached to it. Are you saying that that's a lie too? This person is cray-cray. Seriously, cray-cray, girl. What's wrong with you?
Go to the
What's
corner and
wrong
talk.
with you? You all right?
Tell them more.
Let
Go
me
to the
know
corner.
now. Are you all right? She said, more, some of these people came in late. They don't know you reading from the court documents. Oh, they don't? Okay, my bad, y'all. My bad. I'm reading from the court documents, you guys. All right. I'm reading from the court documents that list all the video footage as evidence. All right. That's what I'm reading from. Sorry if y'all didn't know that. I thought maybe you did. Damn. I'm reading from the court documents that shows all the video footage, the proof attached. Okay. They have video footage of what is being alleged. She didn't just make these statements. She made the statements and she referenced video footage showing that witness number 3 was not where she said she was. Okay. She said, what is this witness gaining from lying? I guess attention. Either attention or I'm not sure what she's gaining, but she absolutely lied 100%.
The witness did say she spoke with the family.
Oh, she did say she spoke with the family?
Yeah.
Like, I'm gonna show you all one of the things without showing let me see. I don't want to show no personal information. All right, let me show you what I mean when I say there's video footage. This is one instance where they mention video footage, but it's mentioned all the way through. It's not just this. This is only just one instance. See where it says see exhibit 7, and in the parentheses it says video footage. Y'all see that? Or bus footage. So that shows right there that she is actually putting exhibits and video footage to back up what she's saying. So this is what's going to be shown in court to the judge. So she can't just say that she can't accuse this person of doing this and then says see exhibit 7, reference the video footage, and it's not what is on the video. She can't do that. That would make her a damn dumbass attorney for her saying, you know, Your Honor, this video shows that she was not where she said she was, or, you know, impossible to hear what she said she heard because this is her at the time of the incident. And now here she go right here at the time of the incident. And here she goes right here at the time of the incident. Then she goes here. The attorney tracked her every move. She said the witness did not lie or more. Q already said that Tamika Johnson is paying you. Holly admitted to shooting her. Well, if Tamika paying me, can I get it, please? I need it. I really need it in my life. I spent a whole lot of money over the Christmas break.
Y'all listening to Q? You getting your facts from Q?
I need the money.
The nigga that said that he seen the tape and he saw Holly chasing Romika around the car with the gun. You listening to Q?
Girl. Well, if Holly is paying me, listen, and I'm a blogger. Holly doesn't, I mean, not Holly, but Tamika doesn't have to pay me, or no one else has to pay me. I am a blogger. I'm getting paid really good by YouTube, okay? I don't need them to pay me. All right? So I'm sorry that you feel that way, Tanya Williams, baby. I'm sorry you feel that way. But I know y'all mad. I know y'all real mad. I seen somebody else put up a video with my picture on it. They must not know about me because I'm going to strike that shit. But nevertheless, I see they put my video up because they real mad at me. You got people coming out the woodwork doing videos on me. I don't give a fuck. Keep on, child. Bring them on. Bring them on. Bring everybody. I need my channel to. I need my channel to go. Bring them on. Bring some more. Talk about me. I don't give no care. So anyway, again, this shows that there is video footage that will be presented in court. Okay. So just, hold your horses. If you guys are not subscribed to my channel, can y'all please do so? It looks like I just hit 16K. Celebration for your girl for hitting 16K on this live stream. Honey, she said, Q lies too, just like you lied to David. You said all these people jumped you and a jump was not had. You just got power punch across the street.
I never said I got jumped. I never once said I got jumped.
Yeah, these people only hear what they want to hear. These selective hearing.
Right, y'all got selective hearing like a motherfucker.
I know. They need to clean out their ears. Somebody said I said that Hollywood gonna never get locked up, and said that I said that Hollywood's gonna be let out the second day. I ain't never said such fucking thing. Boy, these people come over here with they damn stanky lies. Oh, your stanky lie. Do the stanky lie. Do the stanky lie. One more time. Do the stanky lie. Do the stanky lie. Do the stanky lie. Y'all be over here with them stanky lies. Your girl got 16K, baby. I done hit 16K. I appreciate all my new subscribers. I really do. I appreciate y'all. And if anybody else want to subscribe to my channel, because I will be covering this story to its entirety. Okay. I will be putting out correct information, not based on emotions or to get a like or a view. And I know Holly supporters is much less than just for Mika. So I'm not worried about trying to get no 20,000 views or anything like that, because I know everybody don't want to hear my voice. But trust and believe, I'm still gonna get the word out because I still have a big mouth. Okay. So if y'all want to ride with me throughout this entire case or whatever, and if you want to hear real truth, real facts, not just emotions, right? But if you want to hear the real deal, Holyfield, make sure you subscribe to my channel and come back. But if you want to hear somebody just tell you what you want to hear, I'm going to need y'all to go over to the other channels, okay? Y'all make sure y'all subscribe over there to their channels, because I'm not just going to tell you what you want to hear. I'm going to tell you the real deal Holyfield, all right? The real deal Holyfield. It's definitely facts over feelings over here. But if you want somebody to tell you a lie, twist it, rub it down, embellish that shit, then I'm gonna need y'all to go somewhere else. I'm not doing it. She said, why is it so easy to believe the lies and refute the truth? Baby, because they stuck on stupid. That's why. She said, read my comment, auntie. Let me see. Where's your comment at, baby? Let me see. Where's your comment?
It's easier to believe a lie than face the truth.
I don't see your comment. I don't see your comment. Oh, here you go. It says, Ray Young, don't you think that's what she's talking about in the motion? The time she said she was calling 911, she was seen on a camera on the bus, not talking to anyone. No type of way affected. What does that mean? I don't know what you're talking about on that one. No type of way affected.
Meaning the witness wasn't affected. Like when she was riding past and she looked over for that little 9 seconds, she didn't have any type of reaction or any, oh shit, somebody over there fighting.
Exactly. She showed then. She didn't give a care. She said the lawyer lied, and so I guess the state is lying as well because they are the ones who turned over the evidence to Holly's legal team. I know, girl, right? They the one gave the evidence to the defense.
That's called discovery, people.
Yeah. Come on. Thank y'all. Thank y'all for celebrating in my 16K. I appreciate it. I appreciate it. She said, more of the story, keep your hands to yourself and make it home. Okay, keep your hands to yourself. Stop thinking that you biggity fucking bad and that you're going to run up on somebody, all right? Just stop. Don't do that. Don't do that. Don't do that. Don't do that. She said, it really don't matter what we say. These people in court did millions of cases. They know BS when they see it. Yeah, you're right. They do know BS. And that's why the defense attorney knew how to break down this witness statement and follow her every move. I would do the same thing if I was an attorney. I would do the same thing. If I was an attorney, I would, and the star witness said this, that, and the third, I would follow the star witness from the time she hit the scene until the time she fucking left the scene. I will follow her every move. And that's exactly what the defense attorney did, baby. That's what the defense attorney did. So she said, free my cousin Holly till it backwards. Now, it's a lot of people mad today. They in their feelings, honey. They even trying to accuse somebody of trying to strike their page. They so in their feelings, honey. They just don't realize that AI have their own, property claim or whatever, personal property claim thing that they do. But these people want to see and try to act like somebody reported their page. Girl, bye. Sit your ass down over there telling them good lies. Girl, bye. Talking about she wasn't blocked in. The hell if she wasn't. The camera says she was. Video footage says she was blocked in. Okay, stop playing. Y'all can't play with video footage. See, that's what they mad at. They mad because video footage caught the right shit. Now, unfortunately, it didn't catch the shooting, but now that just puts the burden harder on the state. They got to prove that shit. They got to prove that that Romika did not run up on Holly. Prove that. Prove that she did not run up on her. But guess what? The defense already said, even if she did or didn't, running up on somebody or hitting them, should I say, does not like she don't have to have a strike or whatever, or even a weapon to prove that she was in fear of her life. But you know what proves that she ran up on Holly? Guess where she dropped at? Right by Holly's car. That shows escalation. That shows that she ran up on Holly. Hey, Cassie, girl, I know you probably happy hearing the defense present these evidence finally.
Yes, I am ecstatic. Okay, I am so ecstatic. And I was actually looking at Nina Johnson's Facebook live when I got the notification that you was going live in 30 minutes last night.
Mm-hmm.
So did you see her Facebook live?
No, I don't go to those losers page. She probably got me all over it. I don't give a damn. All she doing is bringing me traction. Tell her to show me again. I don't give a damn.
Man, listen, she said she actually had somebody on, a guest on her page that came on camera. Well, she didn't come on camera. She joined her Facebook Live, and she said that. Hold on, I was looking at the game. Let me turn the TV down. Um, she had somebody to join her live that said that she was actually locked up for 4 days with Holly, and I just wanted to clear some shit up because I had a friend that was locked up in the county and she was pregnant. I'm not going to tell her charges, but this was last year. And they take you, when you're pregnant, you go to this, it's called CERMAC. It's under the tunnel. You don't go outside the building. You go under the tunnel to get to CERMAC. It's a big ass hospital. And so on one side, they have, she said that they have like the psychiatric ward, then they have the wing for the pregnancy, but it's not all connected. And you don't share a room. It's not 5 people in a room. The girl was saying that Holly had 3 white roommates, a Hispanic roommate, her, and a white room. Well, 3 white, Holly was black, and then 1 Hispanic roommate. And she basically just hung out with them a lot in the day room. She said that Holly was not taking her medication, her prenatal vitamins and stuff. She hadn't showered the 4 days that she was there, and she was not eating, and that she was actually starving in there.
Oh my God.
Yeah, so the girl was like, yeah, I just paid attention. She stayed on the phone a lot, talking to Carlos. And then the girl slipped up and said, the people come in to the dorm and they grab the pregnant women to go take their prenatal vitamins. And she said it in the live. She would leave out to go take her prenatal vitamins, then come back, and then they have visits where they have to go and see the OB doctor. So she did do that, but other than that, she would just hang with her roommates. And I was sitting here listening to her, and I had to call my cousin, and I was like, "Is this they did like did this change? Y'all have 5 people to a room?" She was like, "No, you have your own room on the pregnant ward." She said it's only like maybe 20 people to each um wing, so they on wings. So it's set up like a hospital. She said it's set up
But what?
exactly like a hospital, and you have your
But
own
what?
room.
But what's the purpose of her saying all this? What is she trying to say? So if she, what if
She,
she ain't taking prenatal vitamins? What is that? So what? I didn't take prenatal vitamins the whole time with my second child.
but I'm
So
just
what does
saying
that
how
mean? It
far
make me
that
feel
they
like,
going to shed some, some bad light on Holly.
oh,
Like why is they watching Holly like that? And the girl
because
basically was like, I kept my eyes on her the whole time I was there. She came back. She had a lawyer's visit. She came back from the lawyer's visit. She was all happy. And I was saying to myself, I know this girl don't think she's gonna get out or something like that. But yeah, she said she got up that morning when Holly had to go to court, and she was looking out her little chuck hole, and she said Holly was all happy. It was like 2 other people who had to go to court that day too, on the 23rd. And then she said Holly came back and she was all happy and stuff. But yeah, she just said she was in there and she was watching her. And when the news came on, because she didn't know about the fight uh, that Carlos was in when they fought at the court. She said so at 4 o'clock or 5 o'clock, news came on. Holly was actually on the phone, and she said she dropped the phone to go look at the TV to see what was going on. But she said Holly was saying, she's like, that's her sister right there. You see how ratchet they is? You see how ratchet they is? So basically, she's like, yeah, Holly and they're still talking bad about Romika and her
I don't
family and
believe
stuff like
that.
that.
That ain't
I
even
don't
Holly.
believe
That
it
ain't even
neither.
Holly. F
I didn't
them
believe
folks.
that shit neither.
But let me address this right quick. Tanya, you must be slow. LD, special ed, or whatever the fuck, right? Seriously. She says, LOL, you body did not drop by Holly car. The document stated that witness number one, which is Carlos, moved the body upper, had all the court documents. Remember, you read them and then you striked her channel. First of all, I never struck upper channel, so use a line, bitch. Second of all, the body was not moved by Carlos, not in a dragging manner. It was moved from the back to the side because she was choking on her blood, you idiot. And it ain't in no goddamn court document. So you illiterate. And if you say some more illiterate shit, I'm gonna kick your illiterate ass up out of here. All right. But anyway, I'm back. I just don't like stupid people. God, I'm allergic to them motherfuckers. Damn.
Well, I'm about to go party, so see y'all later.
Go party, have fun, be good. All
I'll
right.
try.
Bye.
Bye.
Okay. All right. But anyway, sorry, Cassie. I'm just allergic to dumb, stupid people.
No, you good. That's what I just wanted to come up and say.
Oh, okay. Hey, Courtney, what's up, girl? I ain't seen you, girl. What's going on?
What's going on, Auntie? What's going on, girl? Trying to
Girl,
recover
honey,
from
they
this
mad, mad.
flu.
These people in their feelings.
I had to come and
These
see what's
retarded
going
motherfuckers coming
on.
out
And I
everywhere. The
had to get
woodwork,
my
everything.
phone messed up, Auntie, so it keep down deleting YouTube on my phone every time I try to download it. So I'm waiting on a new phone to come. But I seen this information come down the pipeline. I had to get Bay phone and come and join the chat.
Oh.
It is the wiggling around the facts for me. I just came up the
Yes.
wiggling. We is wiggling around the fact that this lady said it's video footage of said witness, the star.
I know, and they can't stand it, boy. They over here hot than a motherfucker. They
I'm
mad.
talking
How
about
they be
6 degrees. Lady, it's documentation saying that you lied. It is
mad?
documented that you looked out the window for 9 seconds. How did you observe a banging on a car if you got off the bus and walked the opposite direction? Ma'am,
Yeah.
so we can't find out if she can get prosecuted for falsifying information to the police? Because this is lies that could cause this lady to go down for the rest of her life, Auntie.
I know she lied. Let me
We
just say this right
big.
quick.
This ain't just small.
If Upper said that I struck her page, she's a motherfucking liar. But this will only be what, the 5th, 6th, or 7th lie she done told in the last couple of days. So if she said I struck her page, she's a motherfucking liar. What the fuck
Tell
I'm
her
gonna
to
strike
show
her
proof.
page?
Tell her to show proof of it.
Exactly. She would never be able to show proof not that I did it. And if somebody struck your page, you will get it will tell you. It'll say talk about it with more. Oh, fucking gap teeth ass, ugly ass, thin hair ass bitch. But anyway, go ahead.
But yeah, you got Bay laughing in the background. But yeah, I just this big to be making up these lies and you didn't see the information that you coming out here reciting to the people, that you giving statement to law enforcement about. This is major. This girl could go to jail for however many years, 40 years. Y'all trying to sit the girl down for the rest of her life, away from her
I
child,
know.
and then give birth to her second child while incarcerated. That's major.
I
And
know
you
the
lied. You looked
witnesses.
out the window for 9 seconds, got off the
Nine.
bus, and went the opposite direction. Somebody help
Yep.
me make it make
With her
sense.
baby. She had her baby with her too.
In the stroller, they walking the other
And it's
way.
still all this shit, right?
You
All this
looked in
stuff.
the eyes,
Allegedly.
Lord. You
Yeah.
looked in the
Somebody
eyes,
looked in her
Auntie.
eyes.
She got
I looked in
elaborate.
her eyes.
She went theatrics,
Let me help you out.
details. She went into
I'm just helping
detail,
a couple people out, getting them the fuck up out of here. Okay, go ahead. I'm sorry.
details. You elaborated. I'm talking about you got down and dirty when I looked into her eyes. I sent my boyfriend to go see. Like you got all extravagant and ain't none of this shit happened. That's a
Mm-hmm.
mental patient. She need to go hug herself in one of them white coats. If you can sit up there, you need to write a play for Tyler Perry. Like, really?
Oh, somebody said she never said I did it. Okay, well, if she didn't say I did it, then I take that back. Take all them cuss words up back. But if she said I did it, fuck that hoe. All right, go ahead.
But yeah, I'm not understanding why we trying to wiggle away from the facts. Got off the bus, had headphones on, got off the bus with her baby and went the opposite direction.
And
So
supposed to have been heard, saw, and seen every damn thing. Girl, stop.
what was going on while you walking the opposite direction? The banking that you seen with the back of your eye, the eyes in the back of your head.
Man, well, let me tell you something. The fact that I found out that they didn't have video footage of the fist bump just made me fall all the way out. I just could not believe that.
I just had
Just-
made it to that part, yeah, and see, because that got me too.
you ain't made it to that part yet,
I know.
Courtney.
I'm talking about in the conversation with me and you right now. I had made it to that part. I'm
Oh,
still on the fact that Shawty got off the bus and went the opposite direction. And somebody she looked
the
in this
opposite
woman's eyes.
direction.
That is
Yes,
mental for
you
me for
did.
you to regurgitate that and you did not see that happen. That is mentally insane for you to say it out of your mouth and that did not happen. You were going the opposite direction when the shots rang out. I cannot make this up.
Yeah, she was going the opposite direction. She was absolutely
Like,
going the opposite direction.
that is
She
crazy.
just told a bold face ass lie. I don't even understand. But I don't think that she knew, and I'm doing this based on her age and her experience in life. She did not know an attorney was going to pull the footage to prove her whereabouts. Like, girl, do you not know that's what they do? They gonna find out where you was in adjacent to where the incident was. And girl, to find out that you was nowhere around, how dare
That's
you?
crazy. The shots rang out and you hiding behind a wall. How you seeing what's going on? How you seeing if that man is helping her or not? He didn't help her. How you know what's going on? You going the other way.
Right. I heard him say, I just dropped my fucking baby off at school. What?
I'ma shoot
What?
you, B. She finna go get her gun, B.
Your
Like, how
gun.
she heard all of that?
I know. I was like, did you say? He was like, no, I ain't say that. I was like, this girl's a liar. Pants on fire. I knew she was a liar already, y'all. I ain't gonna
Now
lie.
you looked out the window for 9 seconds and sat back down in your seat with your baby in between your legs until you got to your stop. And you got to your stop and got off the bus and went the opposite direction. But you seen all of that take place. I just can't get over that part. But now we'll move on though. The fist bump. So you telling me there ain't no video of the fist bump?
Girl, it
Now
is
that would have
not
been
no
the first thing that the defense, say the
video.
state should have gave.
That's what the state used to keep her detained, remember?
Right. That
They
should have been the
used
first
that
thing
to
they
keep her
presented.
detained. Girl, they said that they got it off witness number 3.
What?
And
What the
mind you,
our video at they talking about?
They got it from witness number 3 and said that witness number 3 didn't even tell the judge that at first. Came back later and told, not the judge, I'm sorry, but the detective that came back later and added that shit.
Got to be more
Yeah,
careful. Somebody,
after she had
please,
been on
dear God,
YouTube.
on today. I mean, I don't know. I don't know. But you know, they've been on our heads. That's all I can say. And Carlos said that the evidence won't come out, but they're just diabolical. I feel like that Whitney needs some type of mental help if she done made this whole story up. That's all I'm saying. Some charge need to be pressed. Some type of repercussion need to be had. This lady could possibly go
Somebody
down for
said
the rest
that,
of her life.
but somebody said that she actually can retract it because it wasn't it wasn't under oath or sworn statement or something like that. It says she got on Keys live saying stuff only people in their immediate circle would know. I think that's what I mean. That's when I knew she was lying.
Yeah,
Man.
talking about her first love and all that type of stuff. Her boyfriend said that on the scene to Carlo.
Oh yeah, she did say that. She said, my boyfriend was like, isn't she your first love? How can you treat your first love like that? Do you not love her or some shit like that? Man,
Right.
girl, you
Yeah.
just
That's your first baby mama. How would you know that his first baby mama? She said that. And every time I asked that question, somebody would say to me, well, she said that she just dropped her baby off at school. Well, that don't even mean that that's his baby. She said it's her baby. So her saying that the baby was dropped off at school don't mean that that's Carlos' baby, the man that's standing right there. They ain't had a conversation about who first love and who first baby mama while this taking place right now. So how y'all and the people in the crowd can identify any of the information? Like,
and the Justice for Ramika people are so mad. And it's not that they're outraged that she lied, and that's what they should be. They should be mad. They should be like, damn, lady, you lied to us. But they're not even mad that she lied. They mad that, one, we're calling it out, and two, the defense attorney figured it out, and three, because they wanted her to be so truthful. They wanted it to be real. They mad. They furious as hell.
Amara, keep it real. They mad because you was the first one to bring it out. They didn't get a hold to it to twist the shit up. You came out with that shit last night. That's why they mad.
Oh no! They came out with it first. I was
About
not the first.
the discovery.
Yeah, the discovery. I did not bring that out. Trina and others bring it out first. Yeah, no.
Okay.
Now, of course, they tried to dispute it. They tried to say things like when they was going over the fist bump situation. So instead of saying it wasn't no fist bump, they say, the defense attorney said it wasn't a fist bump. She just don't have everything yet. The state have not turned over everything yet. And then the one about she ran up to Holly and struck her in the face. Oh, the defense attorney is just saying that she's trying to do whatever to just get her client off. She's just saying it. And then the one about the defense attorney saying that she was blocked in. We already proved that. We proved that she was not blocked in. Girl, you ain't proved a damn thing. You ain't proved what the video proved. The video footage says that she pulled up and blocked her in. Period. Blocked her in. She blocked Holly in. Holly was blocked in. So if you hear any creators say that Holly was not blocked in, they are lying. Holly was absolutely blocked in. And if I'm not mistaken, let me look at here and see that she got a video footage of that right quick. Let me see something.
I think you said something about the CTA bus video.
Yeah, I'm just gonna see where she put that at, and I'm just gonna show y'all if it shows that the blocked in part. Let me see. Okay, right here it says. Okay, hold on. At approximately. Well, this is what it says. Let me just take a screenshot of this. And then let me just cover her name just so well, do they have any first name? Oh, they do. Let me
Right. And
just
then
correct.
they trying to say that it was, the people that are standing with Holly in her self defense is the ones that released the witness information. It was not
No,
Holly, no
we
support.
didn't,
They released
yeah,
the name of the witness. It was not.
no, we didn't release the name, but we released the mugshot. But all you got to do is just put the name into Facebook, and 2 mugshots come up. They released the name.
Yep.
We just put the name in the in Facebook, and 2 mugshots come up. Ask them what they think about the mugshot. Hell, she got 2 of them that's floating out there on Facebook. But they released the name though.
Yep.
Yeah. They released the name. So when they release the name, I continue to say the name, and they ain't gonna stop me from saying it. I don't give a damn how much they call themselves trying to threat. They can't threaten me. You can put anything you want on your damn community wall. I don't give a fuck about that. Hell, her name is in the goddamn public ass documents, you idiot. Fuck out of here. Anyway, it says at approximately 8:51, a white Kia, blah, 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 blah. It says the victim blocked. Okay, hold on. The victim blocked Mrs. Johnson car. Let me see. Did it mention that before? Let me see. Hold on. Let's see if it mentioned it before. Black Mercedes. The Johnson placed her car in the back seat. Okay, yeah, it just starts right here. All right, it says at 8:51 a.m., a white Kia sedan driving eastbound on Cermak is captured on camera making a U-turn facing westbound on Cermak. See Exhibit 2. So the shark camera caught that. Victim owned a white Kia sedan, The victim blocked Mrs. Johnson's car by double parking her white Kia on Cermak facing westbound. Now it says ID. What does that mean? ID at 18 through 20. Now, Mrs. Johnson and Smith did not invite. Let me find out what that means. Right, say ID at 18 to 20. I don't know what that means. Let me find out. What does this mean? Hold on.
I would think it's probably identification ID.
Yeah, but I just want to see. I don't know what it means. I want to see the what it says. Give me a sec. It might be from, I don't know. Anyway, let's look. What does this mean?
I think it's saying in the Exhibit 2 video that you can identify that at 18-20 minutes. So in Exhibit 2 is where she is saying that it's seen it, and you can identify that at the 18-20 minute mark. That's what I would assume that it means. Just like right there where she got it down at the bottom where you got please leave me alone. She said identified it in Carlos's with his statement to the detective at you can identify it at the 3 minutes 17 through 27 mark. So she's saying identified it at that mark in Exhibit 2.
It says it means ID at 18 through 20 means same transcript, same page, now referring to lines 18 through 20. It's a legal shorthand so lawyers don't repeat the full citation. Hold on, let me just ask it. Hold on. Let me just ask something else because I just want to make sure I totally understand what they're saying. So is this saying it is identified in a different portion of the motion or footage?
The last bit of evidence that she cited was Exhibit 2. So she got to be referring back to identify at Exhibit 2 at 18-20 minute mark.
It means the same hearing, same transcript, same page, just different line on that page. So the defense is saying we already cited we already cited this transcript. Now look a few lines down on the same page, lines 18 through 20, where the additional detail appears. Oh, let me see. 18 through 20. Well, she got a lot of that in here. Shit, I don't know what that means. But anyway, so basically it's saying that they already,
You get what I'm saying?
it's already cited somewhere in here, but I don't know where it's cited at.
So she
So anyway,
said in the right above that, you see what she say, see exhibit 2, then in parentheses it say Sharks external street camera, victim owned a white Kia sedan and it is used to drop her son off at the school on 55 West Cermite, the son whom she shares in common with Smith, December 2025. So right there she's citing something as well, TR, at the 5-minute 5:14 through 5:17 minute mark. So then the victim blocked Miss Johnson's car by double parking in her white Kia on Cermate facing westbound, identified at 18 through 20 minute mark of exhibit 2 that she already cited up there. That was her last sighting, so she would have to be identifying it in shorthand. That's why she just simply put ID at 18 to 20 minute mark.
I was 18 to 20 minute or 18 to 20. I don't know. Okay.
And
I kinda,
the Sharks, the external street camera video that she got in parentheses, exhibit 2. That's what's right there. So that camera is what she's saying you need to look at the 18 to 20 minute mark of that video footage.
I don't know if that's exactly what they're saying, but basically it's saying whatever it was already cited. But I don't know. So anyway, I kind of understand what you're saying, but it's all throughout this thing. It says that throughout a lot. So basically, it's just citing, it's just saying, basically, like you said, I've already stated something in reference to this, and I'm not gonna write it
Yeah,
all
and
out.
go right here and look at that if you want to see it, basically.
Yeah, so that's lawyer talk. Shit, ain't got shit to do with me. That's lawyer talk. Yeah. Janelle said, I would never believe an eyewitness statement unless it's backed up by forensics. Eyewitness statements is why there is so many innocent people in prison. I agree with that. It's so many people will lie. And, it's almost like they will lie to get your ass in trouble. It's so many eyewitnesses that have lied for whatever the reason. Because somebody was like, why would they lie? There's a lot of people lie. A lot of people lie. Why would somebody say your husband is dating a white girl? Like, people lie. The fuck? People just lie. Normally, lying to the police is a crime, and you can be by
Saying
making.
that this girl is lying. Ari is saying right now that she sat on a bus with headphones on her head. She only looked out the window for 9 seconds. So how did she see a car being banged on somebody being put in the headlock, somebody banging on a car? She's saying she only looked out the window for 9 seconds and the bus was still in motion while she was watching. So they
Yeah,
were
it didn't even stop. The bus didn't even stop at the light. Like, lady, you just did the most. She just did the most. She was deep in her feelings. Something's wrong with your phone, Courtney.
Is it?
Okay, it's better now. That's the time for them to stop the video to see her blocking her in. Oh, is that what it is, Erica? Yeah, I don't know, but I mean, it's to me, it's the Justice for Ramika people trying to spin this, trying to say that some people even say Ari needs to. Let me tell y'all this,
That she
Cassie.
incompetent.
No, Cassie, you got to hear this one. Some people said that Ari needs to be arrested.
Mm-hmm.
They probably already think I deserve to be under the jail. But some people said Ari needs to be arrested for filing this motion. This is how whack some people level of thinking and processing is.
Yeah, they weird.
They are weird. Like, where do these people come from? They literally said Ari needs to, and then somebody said Ari's motion is weak. Baby, it ain't shit weak about this motion. Matter of fact, let me ask. Hold on, I'm about to ask ChatGPT something. Hold on, aloud. ChatGPT, can you hear me? Okay, hold on. ChatGPT, can you hear me? Loud and clear. Is this motion weak or strong? Overall, hold on. I gotta undo this. Hold on a second. It shows this echo bullshit. Hold on. Let me take this beats off. All right. Y'all tell me if y'all hear it now. Hold on. All right, ChatGPT, can you hear me? Absolutely. Great. I'm right. Oh, it's still doing the same shit. Hold on. ChatGPT, can you hear me? Yes. Absolutely. I'm here and I can hear you loud and clear. Okay. Is this motion weak or strong? All right. Let's break it down. It's actually pretty strong. Let me just tell you what it says. This thing is doing the most. It's doing this echo thing. I'm just gonna tell you what it says. Hold on. I don't know why it's this echo thing. Is this motion weak or strong? Let's do it again. Is motion weak or strong? Is it not hearing me? Oh, let me just type it. God damn. Is this motion weak or strong? And be brutally honest. All right. All right, it says brutally honest. This is a strong motion. It's not perfect, but solidly strong or solidly strong. It rates, she's outrated 7.5 to 8 out of 10 at the detention stage. Here's the no bullshit breakdown, the good and the weak. Let's talk about it. Why this motion is strong. It attacks the right legal standards. This is critical. The defense is not arguing guilt or innocence. They stay focused on what the courts must decide right now. It says proof, evidence, and presumption great, real and present danger, no. Proof, evidence, presumption great, no. No conditions could mitigate. That shows the lawyer understands the Pretrial Fairness Act, not just vibes. The judge respond well to motions that stay in their lane. The video versus witness contradictions arguments is powerful. This is one of the strongest parts. The defense doesn't just say the witnesses are lying. They say witnesses claim things that the video contradicts or fail to support these claims. Timelines don't line up. The distance plus the headphones plus the movement that matters. That's how you legally weaken credibility without accusing people outright of lying. Judge takes that seriously. The U-turn plus blocking the car matters more than people realize. That's not fluff. It supports initiation, lack of escape, intimacy, and reasonableness of fear. It directly undercuts the state she could have just left narrative. The order of protection is a big credibility booster. Courts respect prior judicial findings. An order of protection that was granted, served, and violated goes a long way towards showing the defendant fear was imagined or wasn't imagined. They gave the judge an off-ramp. This is smart luring, how do you say that word? They don't just say, you must release her now, no conditions. They say electronic monitoring, home detention, strict condition. Judges like options. It lets them feel balanced instead of reversed. Now, where this motion is weak, all right? Heavily reliance on Carlos Smith. This is the biggest vulnerability. He's involved. He's emotionally connected. He has motive to protect her. Even if he's telling the truth, judge discount interested witnesses. This doesn't kill the motion, but it limits how much weight that piece carries. Change in circumstances is borderline. The section is the softest. The judge could say, this isn't new evidence, it's just better framed. It worked procedurally, but it's not the motion's strongest punch. Some arguments bleed into trial level persuasions. A few spots feel like, here's why she'll win at trial. Judges don't love that at detention hearing. That they want narrow, disciplined arguments, not fatal, just less elegant. No independent third party eyewitness fully clears her. That's reality, not lawyer era. The defense does well attacking the state's witness, but there's no neutral bystander saying, I saw X clearly. That means the judge still has discretion. The realistic judge outcome, based on the motion like this, the most likely outcome, she will be released with strict condition, home detention / EM, or actually it says no continued detention becomes harder to justify. The less likely but possible, the judge keeps her detained, citing serious plus unresolved facts. But if the judge denies this, the defense has strong appellate posture. The final verdict, and this is brutally honest, this is not a weak motion, it's not a sloppy motion, it's not internet lawyer nonsense. It's a real appellate ready detention challenge that exposes holes, uses video intelligently, respects the status, give the courts a way out. If this was weak, I would tell you this one has teeth. So basically it says this is not a weak motion, but it's not like a 10. It's 7.8 to 8% out of 10. So did y'all hear me?
Yeah, I heard you.
So it's not weak, but it's not the strongest. But it says the motion relies heavily on Carlos Smith. How? Where does it? I guess you mean why he ran up and hit her. Where does it rely? I just want to know. Heavily on Carlos, witness number 1. All right, let me see where it said it relies heavily on Carlos. All right, it says, physical aggression and first strike. Okay. It says it relies heavily on Carlos, but hell, he was the only one there. It says it relies heavily on Carlos' statement of physical aggression and first strike. Specifically, they described the confrontation escalated from verbal to physical. What Carlos provided, he tells the police the victim ran up on Ms. Johnson, swung at her, and made contact with her face. Why this reliance matters, the fact is critical to self-defense, but there is no video capturing the punch, no neutral witness confirming the strike. So the defense is leaning on Carlos' credibility for this key escalation. This is the single most important place where Carlos' testimony carries heavy weight. Verbal pleas. Oh yeah, she begged her to please leave me alone. Okay, verbal pleas to de-escalate. Where in the motion? Same self-defense narrative section during the description of the argument prior to the shooting. What Carlos provides. Carlos says Ms. Johnson repeatedly said, please leave me alone. Why this reliance matter? This supports Holly not being the aggressor. Her attempt to disengage, but again, no audio, video captured these words. No third-party witness confirms hearing them. This portion again depends on Carlos' account. Who initiated the confrontation verbally? Where in the motion in the timeline describing the victim approached after the U-turn? What Carlos provided? He recount victims yelling, I told y'all I was going to catch you. Why this reliance matter? This line helps establish prior threats plus follow through. Aggressive intent at the scene, but no independent recording captured that statement. It's not corroborated by other witnesses. So the motion again leans on Carlos at the source. The sequence of events immediately before the shooting, where the motion in the narrative reconstruction of the moment leading up to the gunfire. What Carlos provided, positioning of the party, that the confrontation escalated rapidly and that Holly reacted defensively. Why this reliance matter? Because there is no video footage of the shooting. Other witnesses did not see the full encounter. Carlos become the only witness describing the complete sequence. Judge typically views this as interested party testimony, even if it is truthful, where the defense does not rely on Carlos. This is an important balance. The defense does not rely on Carlos for a U-turn. That was video evidence. The double parking blocking the car, that was video evidence. Oh, it says it was video evidence. The double parking blocking the car, that was video evidence. Plus the transcript. The order of protection is court record. Witness number 3, credibility problem. Bus footage plus body cam, lack of fist bumps, absent of the video. Distance and headphones, video evidence. Witness number 4, speculation, his own words. So the motion is not built entirely on Carlos, but key self-defense elements are. So let me ask you something. So does the state have to prove that Carlos is non-credible, or does the defense have to prove that Carlos is credible? All right, let me just see about this one. It says, great question. And this is a core legal point that a lot of people misunderstand. Short answer. At a detention hearing, the defense does not have to prove Carlos is credible. The state does have the burden to show that its version of events is reliable enough to justify detention. Now let's break that down cleanly. Who has the burden and for what? The state always carries the burden. At a pretrial detention hearing under Illinois law, the state must prove by clear and convincing evidence that the proof is evidence presumption great, and that the defendant is a real and present danger, and no condition can mitigate that danger. That burden never shifts to the defense. What the defense job actually is, the defense does not have to prove Carlos is telling the truth. Instead, the defense only has to do one or more of these: introduce reasonable doubt about the state's narrative, show the evidence is conflicting, incomplete, or unreliable, show the state witnesses are not clearly more reliable than the defense version. If the evidence is murky, contradictory, or evenly balanced, the state fails. How Carlos fits into that framework. The defense does not have to prove Carlos is 100% truthful, prove he is unbiased, prove his story beyond a doubt. The defense does offer Carlos accounts as one plausible version, use video gaps and inconsistency to show the state cannot rule it out, argue that the state witnesses are not clearly more reliable. So Carlos doesn't have to win. He just have to not be disproven clearly and convincingly. Does the state have to prove Carlos is lying? Not exactly, but practically speaking, the state must show that Carlos' account is not reliable enough to create doubt. That can be done by contradictions, video disproving him, physical impossibility, and stronger neutral witnesses. If the state failed to undermine him and the evidence stays mixed, detention becomes legally shaky. Why this matter in this case? Here's the key reality. There is no video footage of the shooting. No neutral witnesses saw the entire confrontation. The state's star witness has credibility issues. Carlos is the only person to describe the physical escalation. That means the state cannot simply say, we don't believe Carlos. They must show, even if Carlos says this, the evidence clearly contradict him. If they can't do that clearly and convincingly, the tie goes to release, not detention. Oh, wow. So Carlos doesn't have to be proven credible. The state has to prove he's not enough to keep someone locked up. So based on the entire motion, the entire defense motion, does the state have evidence that has been presented to the defense team to, what's the word I'm asking? to Carlos' account. All right. Based on the defense motion itself, the state has not presented concrete evidence that definitively disputes Carlos Smith's account. The dispute Carlos' account is a legally meaningful way. The state would need to present reliable evidence that affirmatively contradicts him, such as videos showing the physical contact did not happen, a neutral eyewitness who clearly saw no punch, physical evidence inconsistent with his story, contemptuous statements, or footage that directly contradicts his timeline. According to the defense motion, none of that exists or has been disclosed. Oh, wow. So either, unless they are holding on to something, which I don't even know if they can, but unless they are holding, let me ask, can the state be holding, I think I asked this last night, holding on to something and not giving it to the defense team? Any evidence not yet released to the defense? All right. It says, yes, it is possible the state has additional evidence, but there are hard limits on what can be legally withheld. Oh, yeah, and the Brady set a firm floor. Here's the clear, honest breakdowns. All right, it says, yes, the state can hold back evidence temporarily. The state can still be in possession of evidence that has not yet been turned over. If the investigation is ongoing, the evidence was recently obtained and not yet processed, is being reviewed for relevance, authenticity, or safety concerns. It's work products, notes, external strategy. It involves witness safety or sensitive material, which court oversight. This is common before trial, especially early on. But here's the big limits, and it's very important. They cannot withhold, I don't even know that word, whatever evidence. Under the Brady versus Maryland, the state must disclose evidence that help the defense, evidence that undermine the state witness, evidence that supports the self-defense, evidence that reduce culpability, evidence that could affect detention decision. Even if the defense doesn't ask for it, even if the prosecutor thinks it's minor, even if it hurts their case, if the state has video, forensics evidence, or witness statements that contradicts Carlos' account or support it, it must be disclosed. What about evidence that hurt the defense? The state can delay disclosure of inculpatory evidence such that hurt the defendant as long as it's disclosed by required deadlines and not used unfairly at a hearing without notice. However, if they intend to rely on it to justify detention, they generally must disclose it because detention requires reliable evidence, not surprise. All right, so we don't know. We don't know if they've released all the evidence. So I'm not gonna say that they have released all the evidence because I don't know. She said, I just read a few pages that Quadesia attorney quit. Is that true? If so, which attorney? Who told you that? Who told you that she quit? Where did you read that from? Whose site did you read that from, Butterfly? Oh, you can't believe all these people. Why would she quit?
Wait, what happened, Amara?
They said that she quit. I'm asking. Why would she do a motion and quit? Let me see. Hold on. Let's see. Somebody said they want her to quit. That's right, Alicia. Doesn't she have 2 attorneys, though? Maybe it was the other. Let me find out. I think evidence can be added at any time. Who said that she had 2 attorneys? LOL. I think she does. I think she has more than 2. I think it's a team of them. Oh, they lying. That's a lie. All right, thanks. Liar, liar, pants on fire. Try again. She did not quit. She said more Holly Aunt is here in the comments. If it was true, she would know. Yeah, it's not true. It's a lie. Lie, 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 lie. All they do is lie. So she did not quit. So stop the cap. They probably want her to quit. They probably trying to run her off. Like they try to run me off. They try to run every blogger that's blogging. And how they try to run us off by, going over there calling us black, bald head, ugly, and all types of derogatory names because they think that's going to make us say, oh my God, they just called me black. Oh, I'm sad. Let me go run and tuck my tail because they called me all types of filthy names. I'm so scared and afraid right now because they dogged me on YouTube and put my picture on a thumbnail, and I'm sad and in my feelings. Oh my God. How could they do that to me? Right? No one gives a fuck. We weren't born just yesterday. Get the fuck out of here. No one cares about your little antics. You're not gonna run us off. Not me anyway. Definitely not me. And I don't think you're gonna run Realty off or anybody else that's blogging on it. I don't think. So cut the crap. She said discovery has been turned over now. If they receive new evidence, then but knowingly withhold evidence, we'll have the case through right out. They just be talking. Yeah. So anyway, the answer was absolutely not. She did not quit. Okay. Because I was gonna say, why would she do a motion and then quit? No, I think this is gonna be a big case for her. Actually, I think this is going to be a really big case for her. She's trying to, get her steps in, get her little credit, her creds, however you say that. I don't think she's going to quit. She said, plus a lawyer just can't quit without recusing themselves in front of a judge. Yeah, I thought so. Yeah, you're right about that. They can't do that. Hey, Meg, what's up, lady? Yeah, you're right. They can't just quit like that. So, yeah. But they probably harassing the dog shit out of her, This is how these mobs do. They probably calling her and flooding her inbox and all this type of shit. She says, I am certain either way, our opinions don't matter at this point. It is now in the courts of the law. There will be a trial and then judgment by her peers. Have a good evening. God bless. Yeah, okay. All right. Bye. Thank you, Vera. Great live more. You're the best. Thank you. Appreciate you. Give the courts a way out. Did y'all hear that? Did we hear what? Give the courts a way out? What gives the courts a way out? She said, Indy Blue. I thought Ramika was shot twice, not 3 times. What Indy Blue said? She says she should have not been released due to the fact that she shot her 3 times. Forget the fist bump, respectfully, in my opinion. Oh, girl. She knew, honey. She just turned into the case. Thank you, Angela or Angie. Appreciate you. She said, was there Ramika for 27 minutes after she dropped off Lil Los? Where was Ramika for 27 minutes after she dropped off Lil Los? I hope they find out info on the camera. Ooh. She said, they said my whole family needs to go to jail just for Holly being related to us. I believe you too, honey. They said I need to go to jail too. And they said the family needs to sue me and all types of crazy shit. The family needs to sue her and get her channel taken out. I heard somebody say yesterday, let's report her channel to YouTube. Girl, get in line. Get in line. Do you know how many people that reported my page? Y'all better stop.
Do they
Y'all
not
remember
know
that?
you work for YouTube?
They don't know. They don't know I work for YouTube. They do not know. She said, good live, I'm more very familiar with these kind of cases. Never doubted that Holly acted in self-defense. Yeah. Thank you so much, Dakota. No, they don't know. You're not supposed to tell them I work for YouTube. No, I'm just kidding. Why are people judging people without knowing who they are, and only God should be judging them? Listen, because people mad. They mad. They've been fed a whole bunch of lies, and now that the lies are uncovering, they're just I think because the lies are uncovering, they're mad about it because they actually believed everything that they've been hearing. And they just don't like that. They don't like being told that this is not true and that's not true and this is not true and that's not true. And oh yeah, she made that shit up and she made that shit up too. They don't like that. They don't like that a lot of the things that they were told was just fabricated. Either it came fabricated from the witness and they took the witness as facts. And that's what they get for taking a witness as facts. Why would the witness lie? Because she's human like you are and like I am. Because we human and that's what humans do. They lie, They may not lie every day, but can't nobody out here say they ain't never lied. Nobody, right? She said it says it just be turned over on a timely manner before trial. Trial is a ways away. Time is vague. Well, I honestly, she said they don't have to turn over all the evidence at once. All right, let me ask y'all something. I'm going to do a poll right quick. I'm going to do a poll. I'm going to ask y'all something in this poll. And then we're not going to stay on here for long. I want to see what y'all say. Okay, do you believe there is more evidence? All right, hold on. All right. Either yes or no on this one. Do you believe there is more evidence from the state to use against Holly? Yes or no? Do the poll, you guys. Do the poll. Do you believe there is more evidence? Because as of right now, the evidence that they have in is bullshit because they don't have any. It's just a weak ass witness statement. So I want to know from you guys, do you believe that there is more evidence to hold against Holly that the state has not released yet? She said, no way this is murder. I don't think it's murder either. She said, if they receive more evidence, and I doubt it, they have to turn it over to the defense. Q did say her car was caught on camera stalking the area day before. Do y'all remember that? Yeah, I remember that. I remember he said that. So let me see where y'all at. Oh, a lot of people said, so far, most people said they believe that there is not any more evidence. Ooh. Ooh, you guys are voting. Ooh, so a lot of people think there is not any more evidence. A few people said it is, but majority of the people saying they do not believe that the state has more evidence to use against Holly. She said more evidence not turned over violates the Brady. They do have to turn over the evidence within a reasonable time of receiving it, or the case can be dismissed. If Ari wins, I will understand the feeling when Johnny Cochran used to win. Yes, the current evidence is very weak. That's not to say that they have strong evidence. There are only new evidence that they had was a lie about the fist bump. I cannot believe they came forward and said they don't have no video footage of that. I'm blown away for that. I'm serious. Somebody said, forget the fist bump. No, don't forget the fist bump. Y'all said it was a damn video of the fist bump. Where is the video of the fist bump? Where is the video of the fist bump? All right, so 70 out of 100 votes so far, you guys, 77% said they do not believe the state has additional evidence. Where are my people at that think that the state is holding on to the smoking gun? Where are my people? Where are my people that think the state is holding on to the smoking gun? Because if the state don't have a smoking gun, how the fuck is this first degree? How is this first degree? What say you, Cassie or Courtney?
Can you hear me?
I can.
I want to know why, if they is holding on to the smoking gun, why they holding on to it? Like, that should have been first thing presented, right? The smoking gun.
Kim Sterling says, do you want to answer this or you want me to answer it? She says, why come Holly not out if there no evidence?
Well, I definitely like when you respond to
Tell her
these
to come
people
back
that cannot
January 7th.
enunciate too well. So I'm gonna let you have it.
All right. So, Kimberly, the reason why Holly is not out yet is because this motion does not go to court until January the 7th. Okay. So the defense attorney just received the state's evidence. She didn't know this before. She didn't know the states didn't have no goddamn video footage of none of the bullshit that they was claiming. She didn't know that. She's just learning this. And therefore, she put in the motion saying that this is new evidence. So this motion is to get Holly out of jail. Now, if Holly is still in jail on January the 7th, then you can come back and answer that question. But you can't answer it when the motion was just put in for the defense to be heard on January 7th saying the state ain't got no goddamn evidence. Okay? She just said that in her motion. State ain't got no damn evidence.
Right. So what you got to realize is during this time, the prosecution has only been the one that was presenting information to the courts for anything to take place, for her to be locked up, for there to be an indictment. It all was on based off of what the prosecution speculated on what the witness accounts were. Now the defense is saying we pull camera footage, this and that, and the other evidence from statements and what have you, and we see that this information is incorrect and my client needs to be released. That is what is going on right now.
No, she won't be released Monday at 7. The 7th of January, which is on a Wednesday, not Monday at 7.
Oh my God.
Oh, wow.
It's actually Wednesday, the 7th.
Of
January.
January 2026.
Yeah, January the 7th. Not Monday. It's on a Wednesday. Hey, Tammy B, girl, you missed a lot. She said, so she'll be out on the 7th. Yes, she'll be out on the 7th, Kim. And if she's not, then you can come ask me all type of questions. But she will be out on the 7th, okay? She will be
How
out on the
old are
7th.
these people?
Child, who knows? She said, I do not trust the prosecution team. Well, I don't trust the prosecution witnesses. She says,
Well, God dog, you got to trust the prosecution. That's who's supposed to get justice for Romika. What are we talking about? Like,
who
who
said
else
they
you
don't
gonna,
trust the prosecution team?
who else is you gonna trust, baby? Like, who hands else do they need to pass this over to so that you can trust them?
The prosecutor know that they're not going to win this case. They already know it. They know it. They knew it before they put this shit in my opinion. I believe the prosecutor probably already said, man, I'm not gonna win this case. Let's fucking screw it up right quick or whatever. So we say we try. Hell, I don't know. But I just don't. And for the people that was like, they gotta have evidence. They gotta have evidence because it ain't no way they gonna charge no first degree murder charge without evidence. Well, apparently they don't.
Right, because Amor, when they left court on the 23rd, that would have been slapped right in Ari's face, right then and there. Boom, here go the evidence. Smoking gun. Pow, pow. Fist bump.
Right.
Here you go. Video. They done it. Congratulations. We got her. They would have showed that right then and there.
Yeah, they would have.
Like, what they would have
Yeah.
waited on for that?
Yeah. They would have showed it quick, fast, in a hurry. If a state case is strong, they ain't holding on to shit. They giving it to them. Here you
That
go.
part.
Here you go. Here you go. What else you need? Here you go. Here you go.
They're like you at the spade table and you going for that last book, Joker, deuce, deuce, and you got the guarantee. You finna slam that song on down. Pow
Mm-hmm.
here we go. What are we talking about?
Right. Right.
Like, and we got to know that some type of evidence was entered for her to say that they don't have enough evidence to prove this. That's why she's saying that in her motion. So something was given to her, and she's saying that what y'all gave me is BS. This is not.
I
What
believe
y'all
that.
holding my client on? Like something was given to her for her to be countering with this motion.
Mm-hmm. Yep. Rachel said, but what is fucked up is that the state knew they didn't have it. Yes. The state knew they didn't have proof of the fist bump when they mentioned it on December the 4th. They knew they didn't have proof of that. But they said it kind of like they did, because what they said was they mentioned the fist bump, and then shortly after they said, yeah, the CTA footage captured some of the incident. But what they didn't say, they didn't lie. They just didn't tell the whole truth. What they didn't say, that it captured some of the incident, but it wasn't the damn fist bump.
Right.
I think the state did all that to appease the public and the family. That's it. That's all.
She said, Amor, can you look up the steps, arrest, pretrial, etc.? Because I keep reading that full discovery hearing has not come up yet. Well, a full discovery, well, hold on, let me see. Full discovery, I never heard of a full discovery hearing. Let's look and see if there's a such thing. Because I don't know if there's a such thing as a full, let me see.
What they trying to imply is that the prosecution still has the opportunity to present evidence. This is true. But what the motion that was filed is saying that what was presented was BS. So come on with whatever you talking about, or let my client go until we go to trial. That's what she motioning right here. Like, just to get to the meat and potatoes of the situation. She's saying the BS that y'all gave me to hold my client is BS. There was no proof of this stuff that y'all claiming happened in what was given.
So it
So
says there is no full discovery hearing. It says Illinois does not have a single routine full discovery hearing where everything is laid out all at once. Discovery happened through rules, deadlines, and motions, not one big hearing. Okay, so what is the deadline for the discovery? Okay, let's find out this. This will disapprove everything discovery. What is the deadline for discovery?
they gotta respond to this motion.
Oh, it says there
Absolutely.
is no single final discovery deadline at the beginning of the case. Oh, so there's no, it says it's ongoing. Oh, okay. So it says the initial discovery is due within 30 days. And that is 30 days of what? 30 days after arraignment. Is that when she was locked up?
Well, I heard that she was gonna be arraigned on the 7th.
Is that 30 days after locked up? Or arrested? After arrested? After arrest? Is that 30 days after the arrest? No, it says it's not automatically 30 days after the arrest. It is discovery starts after arraignment, not arrest. What is the arraignment? What
Carla,
is the
David just put
arraignment?
in the chat what he said he saw on the Sharks camera. Auntie, if you want to pin that comment, because people in the comments was asking what did David say he seen.
It just showed Los, Holly, and the baby leaving out the crib, loading the baby in the bins, then driving off. When did they show that?
David
Right.
saying that he personally seen that from the Sharks camera footage.
Hold on. So is this the detention hearing?
I just want to say that they be talking about the sisterhood, but the sisterhood is strong. Everybody noticed that I have been missing in action and y'all were concerned about me. And they say that the sisterhood don't be sisterhooding. Yes, they
Mm-hmm.
do.
Mm-hmm. Yep. So wait a minute. So the arraignment is not the detention hearing. So have she
The
went to
arraignment,
it?
no, she hasn't. She hasn't with the arraignment yet. That's supposed to be on the 7th. That's a part of what's taking place on the 7th.
Oh, okay. So it's 30 days after that. They have to have the initial discovery turned in 30 days after arraignment. So It says many courts expect 30 days, but that's practice, not hard rules. Oh, okay. It says they have to have the police report, witness statements, available video, defendant statement, and physical evidence lists. Oh, okay. So it says that they can ongoing is the word they use. They can continue to disclose newly discovered evidence. So they can continue to do investigation or whatever and come up with evidence. But as they get it, the Brady law says as they receive the evidence, they must turn it over immediately. So as of right now, what they have turned over. They're not holding on to anything. New evidence, they turn over as it comes in. So as of right now, they don't have any other evidence. Is that what that's telling me? So
Yes,
hold on.
that's correct. That's correct. That's what that's telling you. They don't have any other evidence, and the evidence that they do have is not enough to, you know, prosecute or convict her. So, they want her to be released.
I said, so are you saying they have turned over everything
Thus,
that they have thus far?
mm-hmm.
And if they receive or obtain additional evidence, they are required to turn over immediately. All right, let me see. It says yes. All right, it says what you said is basically correct, and there's the precise legal accurate way of saying this. Yes, as of now, the state is required to have turned over everything it has thus far that is discoverable and relevant, especially anything that affects detention or helps the defense. And yes, the state later receive. It says if the state later receives or obtains new evidence, it is required to turn that over on a rolling basis, not just sit on it. All right, so what they have thus far, they've already turned over. So what they have thus
Meaning
far,
that said fist bump should have been turned over if they have that.
they already told the defense that they don't have, it's not on tape. It
That's what
says
I'm
in
saying.
this motion, it says in
Uh-huh.
this motion that they relied on witness number 3.
Yeah. So they are basically saying that, state lied. They don't have a video of said fist bump.
Yeah, that's true. It says arraignment is where she learns her charges and enters her plea. Yep, that's true.
Yeah.
So as of right now, the evidence that they have, they've turned over. If they receive new evidence, they have to turn it over. But for right now, they're not holding on to anything away from the defense. So as they get it, they have to turn it over. So whatever they have as of right now, they've turned it over. So they're not holding on to anything. She said they never said they had it on video. Well, they kind of implied it, Nicole. And the supporters said that they saw it. The Team Ramika. Even some that support me, that's Team Ramika, said that they saw it. I remember them telling me, Amora, I saw it. I promise, Amora. I promise I seen it, Amora. So a lot of Ramika supporters or Team Ramika or just for Ramika actually said that they saw the video. But a state attorney saying, where the video at? Because I don't have it. I was just relying on the witness statement. The witness that the defense attorney basically discredited already. She says seeing it and having it on video is not the same thing. You absolutely right, because if it's not on video, that's just your word against theirs. So seeing it and having it on video, yep, it is absolutely not the same thing. Seeing it don't mean shit if you can't prove it. If you can't prove it, if the state can't prove it, it don't mean shit.
Which
Not
is
nothing.
again why Ari going so hard to discredit said witness, because witness is documented liar. Okay, she was on the bus with headphones, looking out the window for 9 seconds, got off the bus and went the opposite direction, but said she was there when all this stuff happened. So now we coming up on the character of the witness and them proving that witness is lying. So we can't believe that she's seen a fist bump if she lied about the rest of that crap.
Right.
Right or wrong
She
now.
said She said not necessarily. Eyewitness account convicts. Only if they can prove it. They have to be able to prove that. They can't, the state cannot prove that. They can't prove it because she wasn't even there. They've already disproved on video that she was not there. She lied. So that doesn't make no difference. She already got caught lying, saying she was there. She was on the scene and she wasn't. She ain't seen nothing. Just because she had on headphones doesn't mean that was on, could have been muted. It wasn't just the headphones, baby. It was the headphones. It was the bus was moving, didn't stop not one time. It was, she was 9 minutes. She only looked out the
window for
window
9 seconds.
She was away from the scene for 9 minutes. She was caught on video hiding behind a building underneath the steps, had a baby stroller going the opposite direction, 350 to 400 feet away. It goes on and on.
Right.
The eyewitness is non-credible, 100%. Her testimony will be non-credible. Her whole entire testimony will be thrown out. Trust me on that.
They don't
I
understand how
guarantee
serious
you.
that is.
I would bet somebody $100 that witness statement would be thrown out 100%. Or not thrown out, but what do they call it? Impeached.
Yeah.
It will be impeached. It will be impeached. Let me tell you this. If the jury hears her, Holly will be free. I promise you that. If the jury gets a chance to hear witness number 3, Holly will be set free 100%. Because the defense attorney will dog walk her, catch her in so many lies. That's the key star witness too.
You got to think about it. She said she seen banging on the hood of her car. So if you only looked out the window and seen for 9 seconds with the headset on, did you see them arguing and talking about whatever they were saying, or was the banging happening in them 9 seconds while you were looking out the window? You sat back down in your seat with your baby stroller in front of you, got rolled to the stop and got off the bus and went the opposite direction. When you seen the banging on the car take place? Your back turned and you going the other direction. How you know what's going on behind you? The crime scene is behind her at this point of her getting off the bus. How
Yeah,
she
she didn't
what's
see.
going on, y'all?
She didn't see. She is not. Listen, she is non-credible 100%. They cannot like it all they want to. She is non-credible. There's video footage that proves that she did not see what she saw. They can say whatever they want at this point. It don't matter. Let them stay delusional.
That's
Let
crazy.
them stay delusional.
The
But she
CTA
is
bus
not
camera
credible.
caught her going a different direction from the incident.
Exactly.
That's all that need to be said there.
Okay, this girl said y'all banking on one witness derailing the case. Girl, they only got 4. Which witness gonna steal the deal? They only got 4, girl. What are you talking about?
Witness number 2 said he was inside the coffee shop when the shots rang out. He just came
And
out
witness
and
number 4
somebody.
said he ain't seen shit. So, girl, have you not seen the motion? They only got 4 witnesses, boo-boo kitty. You talking about we banking on one witness derailing it? The goddamn the state banking on one witness to seal the deal.
Exactly. Witness
She
number
said,
2.
okay, let the jury decide. If you don't want to hear what we got to say, you can always exit stage left. You don't have to sit here and listen to us talking about let the jury decide. We're going to help the jury decide, okay? We're going to talk about it over here. And if you don't want to hear us talk about it, you know you can always go back over there to the Team Romika side and listen to them good telling lies, girl. Go on over there and get your feel good on, honey. Go on over there and get your feel good. I encourage anybody that want to feel good, that just want some emotional feel good, to go on over there and fill up on that shit. Go on over there and fill up on that.
Just can't get over it, man. I don't know what to do with it. I don't know what to do with it.
She talking about we banking on one witness derailing the case. Girl, there's only 4 of them.
Right. Witness 2 said
And
he
one
was
of them
inside the
is
coffee
Carlos.
shop picking up a DoorDash order. When he came out, she was in handcuffs. That's how he know who shot. Okay. Witness number 4 is the security guard at the school, and he said that all he heard was she got a CCL, and she just put 2 and 2 together and came to the conclusion that they was shot. So what are we talking about?
Go tell Keys to come unask all them other witnesses that he said there was that he said the state had. Tell him to go unask all them other witnesses. Then they say they had like 14 or 15 witnesses.
39
Listen,
I heard at one point, god dog.
Child, the state got 3 witnesses, baby. Pick one. Any minute, mighty mo, catch your witness by his toe. If you hardly let him go. I don't even know the words. But
Right.
she said the star witness lost her star. She showed it.
She did.
She lost her star and it ain't even
She got
started yet.
question marks now.
Mm-hmm. There is no evidence. She said,
The
looking forward to letting
questionable
the jury
witnesses.
hear all the evidence. There is no evidence, Nicole. There is no evidence. Okay, baby? No evidence.
Whatever evidence.
No evidence. She said, will Holly take the stand in her own defense? Like, girl, you jumping the gun. Shit, can we get her out? Can we get her out on January the 7th first? Can we get her out first? Good Lord, child. She talking about will she take her own defense? She might. I don't know, but she don't have nothing. Let me tell you something. If I was her, I wouldn't say shit. You want to know why?
Because the
Because
burden of
she
proof
ain't got
reside
to
on the state.
prove nothing.
That's right.
The burden of proof is on the state. The state got to prove that it was not self-defense, period. They
Ma'am.
got to prove that it was not self-defense. She said there was enough evidence to charge her. It was speculative. And that's why now that the defense has the
Video footage from the
discovery,
CPA camera. Yep.
now that they have the discovery, they're going to prove on the 7th that there is not enough evidence to hold her. You can charge somebody because it was an unaliving. An unaliving took place. An unaliving took place. But let me tell you something. You said there was enough evidence to charge her. So you can always, they could charge on, what's the word they call it? Not reasonable doubt, but
Probable
probable
cause.
cause. They could charge on probable cause because that's a low bar. Probable cause is a low bar. A reasonable doubt is a higher bar. A reasonable doubt is a higher bar. Okay. So probable cause and reasonable doubt is 2 different things. It's a lot of people get charged and end up getting self-defense. She said, I doubt seriously she got all the discovery this soon. Why? It happened in September. They've been working on this since September. Why wouldn't they have all of it? Why wouldn't they have it all? They've been investigating this case since September. It's December, September, October, November, December. I mean, they've been investigating it for a minute.
They were supposed to slap all that out there. Like I said, the guaranteed paid. Ding, 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 ding.
She said, Amor, you look up how often Cook County murder cases fall apart due to the witness. Let's see.
Keys the Mo, exactly. They gonna move the goalpost. Keys the Mo said now that they know the witness statement got holes in it, watch how they change the narrative. Yo, they gonna definitely try to change it now that they see that the hole is holes in the witness statement. They moving the goalpost now. You see, said person just said, well, they relying on one witness to derail the case. Well, that was the star that was supposed to seal the deal. Now she caught lying.
Mm-hmm. All right. I put the question in the way you asked it. All right. It says, how often do Cook County murder cases fall apart due to a witness? It says there's no precise public statistics, but murder cases can be dismissed or weakened when key witness recants, crucial eyewitness become non-credible, and major evidence disappear. However, murder cases do not collapse solely because of one witness. Prosecutors often have multiple forms of evidence, forensics, video, or other witnesses. In Cook County specifically, case rarely fall apart completely just for one weak witness, unless that witness is the cornerstone of the state's entire prosecution. So unless that's it, you know what I'm saying? She said, isn't Carlos a star witness? Not for the state, baby. No. The star witness is witness number 3, baby. Actually, Carlos is not a state witness at all. The state witness, the star witness is witness number 3. Botella is her name. Shaking my head, I just be trying to go back and forth in the comments with these emotional, unstable people. She said, these folks got to use their common sense at some point. They got to realize their emotions want Holly guilty. Yep, the emotions want Holly guilty. You are absolutely correct about that.
I think
She said, I guarantee the prosecutor is having a whole conversation with witness number 3. They trying to clean it up, child. I'm pretty sure they probably, I don't know, they probably should have did their homework. She said, I saw where some of Ramika supporters posted something about contacting the FBI about this case. Woo, child, I thought they had already wrote the people. Child, this ain't no different than what we already done been through. You hear me? Child, they be talking about I'm calling the FBI, the president, the damn vice president, the damn everybody. Child, let them go ahead. Write the FBI. You sound dumb. She said, if you go back to the part where you read about Carlos, it's something important you missed, like the statement giving the courts a way out. Which one, sister teacher? Giving the courts a way out. What do you mean? Tell me. Why would the FBI mess with this? They're delusional. I know a state case. Oh, the FBI gonna come in and she said, ask what does it mean? What do you mean when you say ask what does it mean? I don't understand what you mean. She said, so are y'all hollering about facts and actual saw the facts, the discovery, witness statements, etc.? You must have just came in. We've been going over the motion for the last 3 hours, and we went over it last night. Just go back to the beginning of the video. I think you'll understand more. She said, now that the feds will get involved, never underestimate. But what would the feds get involved and do? What the feds gonna do? Get involved for what? She said, when you read Carlos' witness statements, go back to that. All right, let me go back to his witness statement. Carlos' witness statement. Let's go back to Carlos' witness statement. Hold on. Okay, maybe I need to label this. Hold on, let me see. Carlos' witness statement. Okay, witness number 1. So what do you want me to ask it? I'm going to the statement and I'm seeing what? We can't hear you, Courtney, baby. I can't hear you. Okay, you said go back to Carlos' witness statement. Stated to the police 2 hours after the incident. You talking about that? All right, let's go to the Carlos' witness statement. So what am I supposed to be looking for? You said they give the state a way out? Hold on. Hold on, let me see. What does give the state a way out means? She said it says his statement could give the court a way out, which means case can be dismissed. When you say give the state a way out, meaning that it can be dismissed, I guess I'm not understanding what you mean. She said the state court hasn't even tried the case. What would be the Facebook task? I don't know what she mean by that. I'm confused on that one. That's what ChatGPT said. Oh, they said that? Hold on, let's go back. Let's go back. Let's go back. Hold on. Where I said that it relies heavily, when I said that the defense relying heavily on Carlos' statement, is that what you mean? I think it's referring to the ChatGPT commentary of Carlos' statement. Where's the motion? Does the defense rely on Carlos' witness? Does the state have to prove Carlos is non-credible, or does the defense have to prove Carlos is credible? It says the state must prove beyond a reasonable doubt every element of the charges of offense. The state does not have to prove a witness is non-credible. If the defense bases motions on Carlos' account, they may argue his testimony contradicts the statement, but the state doesn't have to prove Carlos is a liar. Based on the defense motion, does the state have evidence to dispute Carlos' account? Can the state withhold evidence? Oh, wait, hold on, let me go back up. A motion could be denied. She said that's what you read in that statement. It started, Carlos' statement can give the courts a way out, meaning the judge can dismiss. Let me go back to see what I was saying that on.
Can Sister Teacher just come up?
If she wants to. She said that I read it though. I'm trying to go back to what I read. I'm dealing between two things at once. Oh, right here. It says, I see what it says. Carlos' statement gives the statement something to argue. Okay, this is what it says. What is accurate and strong? All right, I see what you're talking about. It's saying, when I asked, hold on. Carlos' statement gives the state something to argue. It gives them a theory, not proof. It helps them get in the door, not to win. I think that's what you're talking about. It says Carlos' account is not just mentioned once. It woven through multiple legal arguments where the defense believe it undermines the state version of events. And then it says, if the defense based motion on Carlos' account, they may argue his testimony contradict the state's theory. So the real issue is Carlos' testimony material enough for casting doubt, or it causes reasonable doubt? She said Carlos' statement is actually going to help the prosecution. He stated he stood between them to prevent physical altercation and his back was turned, moving his vehicle. So how did he witness the shooting? I don't even think he said he witnessed the shooting. In the statement, I don't see that. I don't see that. Not in this statement, but I don't think this is the whole statement. I think that she just kind of summarized it a little bit. I don't think this is the whole statement. I guess we'll be getting the whole statement soon. So anyway, but I done been on now almost 4 hours. I'm about to get off. Romika was a menace to Black women. Why are so many Black coming in support of this unstable bully? Because they don't want to say what they thinking. Oh, she said you read that last night. Oh, I did? I don't know. She said, no, the document you read. I don't know. She said, Lord, the day we support killers, we have reached a new low. This is the saddest thing ever. Y'all blame Ramika for getting killed, but glorify Carlos for setting it up. Sicko folks, good night. All right, let me just help you out because we sick of people like you. Take your ass back across the street and go color. God damn, what's wrong with you people? I'm talking about you glorifying a killer. Child, everybody that shoots somebody in self-defense is not a killer. You think she's a killer because that's what you want to believe. Take your goofy ass on. Good Lord. There be so many goofies in here. We be trying to have patience with y'all, but y'all keep on. Damn, get the fuck out of here. Fuck. Damn, what's wrong with these people? Delulu, too much switching up for me. They need to give up YouTube and go be a fictional author and write books, especially Professor Clump. He needs a comic book. She said, Amora, these were Mika supporters. My God, so stupid. Girl. She said they weird as fuck. And R, she said Q is the one that said Carlos was moving his vehicle. So Ramika can move instead. She went back toward Holly. Carlos did not say anything. More Google, why would the state take a case they know they cannot win? All right, why would a state take a case they know they cannot win? All right, let me see what it says. It says, all right, I said, why would a state charge first degree murder even if it's not a sure win? It said proper cause does not equal proof beyond a reasonable doubt. This is the biggest misunderstanding. To charge someone, the state only needs probable cause. To convict, they need proof beyond a reasonable doubt. Prosecutors often say, we may not be able to prove this yet, but we have enough to charge and investigate further. Charging early gives them time, leverage, and control. They let a jury decide hard cases. Prosecutors are not required to only bring slam dunk cases. In closed cases, especially self-defense cases, they often think this is controversial. Let a jury sort it out, especially when someone died, public emotions are high, family pressure exists, media attention is intense. Walking away without charges can look like favoritism or neglect. Political and public pressure is real. This matters more than people want to admit. In Cook County, high-profile death, public outrage, social media campaigns, and victim family advocates can push prosecutors to file the highest charges possible, even if they later reduce or lose. Sometimes charging is about showing we took it seriously, avoiding accusation of bias, and letting the process play out publicly. Charging high gives bargaining power. This is strategic and calming. By charging first degree murder, the state keeps all options open, preserve leverage for plea negotiation, avoid being accused of undercharging. They can later reduce the charge, accept a lesser plea, or lose at trial without admitting any error. If they start low, they can't go back up easily. Evidence may strengthen later. Prosecutors often believe witnesses may change, forensic evidence may come back, digital evidence may be recorded, pressure may cause cooperation. So they charge based on what they have now, betting it improves. Sometimes it does, sometimes it does not. Self-defense cases are especially hard. In self-defense cases, credibility matters more than videos. Intent is subjective. Fear is contextual. Juries are unpredictable. Prosecutors sometimes think even if self-defense is possible, a jury might reject it. That's enough for them to proceed. Losing a case isn't career ending. This is uncomfortable but true. Prosecutors loses cases all the time, rarely faces consequences for filing charges, are judged more on conviction rate over time, not one loss. Failing to charge, however, can be career damaging in a high-profile case. What this means for this case, real talk. Charging first-degree murder does not mean the state is confident, the case is strong, conviction is likely. It means you believe that they can legally justify the charge. They want a jury to decide. They are willing to risk losing rather than not charging. All right, charging a case doesn't mean the state knows it can win. It means they believe that's enough to move forward and let a jury decide later, especially in serious, high-pressure cases. All right, prosecutors don't need certainty to charge, only enough to proceed. All right. She says you can get a similar answer if you ask the question like I wrote it. Amor asks, why would the state take cases they know they can't win? Didn't I do that? Isn't that the same? All right, let me take out first degree. All right, I'm taking out first degree. All right, why would they? All right, hold on. It says prosecutors don't need to guarantee a win. They need probable cause. The job isn't just to win, it's to seek justice. According to the Supreme Court precedents, a prosecutor duty is to see that justice is done, not merely to rack up convictions. That means they can pursue charges when, based on the evidence they have, there is justified legal basis to proceed, even if the evidence will later be challenged or appear weaker at the trial. They only need probable cause to charge, not certainty of winning. Probable cause is a much lower standard than proving beyond a reasonable doubt. Probable cause means there is reasonable base to believe a crime was committed by the defendant. Prosecutors can ethically file charges if probable cause exists, even if they personally aren't sure they can convict beyond a reasonable doubt. The key point is the rule allows charges when predictable cause exists, even without certainty of a win. The decision is to charge may rely on what investigators produce. Prosecutors' charge decisions are generally based on the evidence submitted by the police, witness statements, physical evidence, forensic results, crime scene evidence. They evaluate whether the admissible evidence could prove the case at trial. If they think it might, even if it's weak, they will proceed. Public safety, deterrence, and community expectation matters. Prosecutors often weigh more than just evidence. Public safety concerns, desire to show accountability, victim impact, and community pressure. Murder is a serious offense. Not filing charges can look like inaction, even when the evidence is incomplete. So prosecutors sometimes file and let the legal process test the case rather than not file at all. Sometimes prosecutors file charges before full investigation is done. Prosecutors can decide differently over time. It says prosecutors can charge even if they don't know that they can win. Ethics require pursuit of justice, not guarantee victory, and charges can still be tested and potentially fail later. So basically, they did this because of they didn't want to look like they just not gonna do anything. So point blank, period. Anyway, y'all, any more questions? Any more questions? Any more questions? I think we all got what it is that we need out of this motion. She said, no one is glorifying the death of Ramika, but we do believe in the Second Amendment. Plus, we have seen enough Ramikas and family characters to know what happened, why it happened. Exactly. Who said that we're glorifying the death? Who said that? Where they at? Who said we glorifying the death? Let me see if I see it. I see y'all talking about nobody is glorifying Holly. Why is she saying that? Who said we glorifying the death, child? I'm looking for him. I don't see him. It must have been that Nicole girl. I already got her out of here. She in her feelings, honey. She gonna go back across the street and woo-saw. They gonna go over there and tell her something that she want to hear. They're gonna be like, don't believe Amora. Amora doesn't know what she's talking about and she can't read. She don't know how to enunciate words, and we're smart, and I live in the state of Illinois and I'm very smart, and only listen to me. If y'all want to listen to them people that's feeding y'all a bunch of bullshit, y'all just go right on over there and listen to them. All right? Go right ahead, honey. I ain't even gonna stop you. I ain't even gonna hate on your child. I ain't even gonna hate. She said, ask what do giving the courts a way out mean? Huh? What do giving the courts a way out? What does that mean? How many times do you have to tell these people the same thing? Girl, child, until they clean out their damn ears. I think I saw a glimpse, but not sure. I can only imagine a big bag with dirty neck and bonnet queen. She lied now. She live now. She said she lit a blunt outside the courthouse and David stole it. Who? Who are you talking about? Who are you talking about? Who are y'all talking about? OMG. Who are y'all talking about? Lit a blunt and David stole it, mean. Everything you just read is what you said from the beginning. Yep, that's true. Oh, Newport. Oh, Newport Live. Oh, Lord Jesus. All right, it says, why judge? Okay, it says, what does giving the court a way out mean? It means the defense does not force the judge into an all or nothing corner. Instead of saying, judge, either you agree with us completely or you're wrong, the defense says, judge, if you have concerns, here are lawful, reasonable options and still protect the community. Why judge need a way out? What? The judge? I don't know what this means. How the defense did this. I don't know. This doesn't make any sense from what I'm reading. This talking about a judge a way out. I have no idea what that means. Shy Newport that started the channel. She said, ooh, let me get some of that moolah grande, baby. Shy Newport live. That shit funny. Anyway, y'all. She said Newport has a channel. Who gonna listen? Yo, all that out of breath yelling. Listen. Somebody probably told her, all you gotta do is just cuss people out. That's what you do. She said, yes, this was another great live. Thank you, Meg. Appreciate you, baby. Anyway, I do appreciate y'all for showing up. I think that we are pretty much clear on a lot of things. Last night I was falling asleep, so I couldn't really get into it the way I want to. But I think, I think we did a pretty good job of showing what the defense is arguing in court on the 7th. Okay. And yeah, I think we're in a good position for right now or whatever. I think she's doing her job the way she's supposed to be doing it. And I'm satisfied with what I'm hearing or whatever. You know what I mean? I'm more than satisfied because I love the way she's not just sitting back and being pushed around. You know what I mean? She's a young attorney in her 30s and she ain't taking this lightly. You know what I'm saying? She's not being pushed around. She is definitely doing her homework thus far. Okay. Now, people ain't going to like her. They're going to call her all type. They already didn't call her ghetto and stuff like that or whatever. They think everybody ghetto like they ain't. Oh, here goes somebody else. Y'all sound so stupid. Holly's in jail for a reason. Duh. Amore is ignorant and y'all follow this dumbass shit. She not getting out. The lawyer took her money and that's the only thing she is winning. Ooh, girl, you sound illiterate. Take your illiterate ass back across the street, okay? Take your illiterate ass back across the street. So anyway, I'm not gonna argue no more with them fools today. All right, that's enough arguing for today. Thank y'all for enjoying this live. I appreciate y'all. Thank y'all for blessing me on this live, and I'm gonna, keep bringing the truth, whether they like it or not, honey. Whether they like it or not, I'm gonna keep bringing you guys the truth and break it down. All right. She said, "Is Newport Maya?" I think so, girl. He says, I can't even smoke weed. My license won't allow me. Listen, these people crazy. Some of these people just start up channels just because they want to fight. Just imagine that. Thank you, S Gum, for blessing this channel, this live stream. I appreciate you. And then you speak of some more love. Thank you, baby. Thank you, Candy and Rachel and Bonita and Sonia and Binky Bean. Ooh, look at y'all throwing the damn money. That's what I'm talking about. Look at y'all, Rita and Troy and Lady Love and Cheryl. We got Margot, and then we got Big Sis Glenn, and then we got Gloria, and then we got Super Leo, And wouldn't you like to know? Thank you for showing the love. Nahimi and D. Lewis, Rachel again, Juanette and Quane. We got Miss Carla. She said, awesome breakdown. Love it. Oh, thank you. Thank you, Candy. Thank you, S. Gums. Thank you, 100K. And Rita, Lacondas, Vera. You know, I just noticed you got 100K, got them mad. Girl, what you said? Vera and Angie and Vera again, baby. Thank y'all so much for the love, support. I appreciate you guys to the max. I do. Before I get off, hold on, because y'all, I be gaining subscribers by the damn moment. Okay. Well, she said 100K, she sure does. What did 100K say? Hold on, let's go back to 100K. What'd you say, girl? What'd you say, 100K? She said, she live for sports. Oh, Lord, child. It'll be all right. She probably thinks she can make some money. Oh, let me go here. Let me give me things of cigarettes right quick. Girl, oh, look at this. Look at the Lord, honey. Thank y'all. I appreciate the love that y'all show me. Let me show y'all. Okay, so listen, let me show y'all something. Y'all are doing a damn thing. So when I started this live, I was under 16,000. And then I made 16,000 while I was live, right? And now I'm about to end my live and I'm at 16,600. If you have not subscribed to my channel, please do so. I appreciate your support. I appreciate your company. And thank y'all for trusting in me. And thank y'all for trusting that I'm going to give you guys the correct information, honey. It's facts over feelings over here. The people that's in their feelings, they can keep it moving, okay? But thank y'all so very much. I am growing, and it's because of y'all. I do appreciate y'all. Y'all have a good night and hit that thumbs up button on the way out. Bye, y'all. Until tomorrow. Bye, y'all.
See you later, Amora.
Oh, I forgot you was up here, baby. I'm going to call you, Cassie, okay?
Okay.
I'll call you. All right.
Okay.
Love y'all.
Okay.
All right. Bye-bye.
Because they can't make $1 without mentioning down one of our names.
She kept talking about that family.
Hoes over there.
She kept talking about that family. 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 That family. She kept talking about that family. Talking about that family.
These motherfuckers got me want to listen on them. Because they can't make $1 without mentioning down one of our names.